Okay, Your Honor, we are now live streaming and we can begin when you are ready.
All right, thank you. Good afternoon, folks. This is round 2 of our mock trial competition, Team FF and Team HH. First, I'll introduce myself. My name is Brad Varmo. I will be the judge of this round. Is each side ready for trial? Team FF?
Yes, Your Honor.
And Team HH?
Yes, Your Honor.
All right, thank you. I have some preliminary remarks that I need to read. I believe I have, and the scoring panelists have, copies of the trial rosters with the team's code. If video recorders are present and being used, both teams need to have approved the taping of this round. Teams and folks watching this need to be advised that the Colorado Bar Association may be taking photographs of the competition during the round, and that team participation in the state tournament grants the automatic permission and use of these photos by the Colorado Bar Association. Anyone who's in the gallery who's connected with teams not competing in this round must leave the courtroom. No recesses will be allowed with the exception of a health emergency. Prior to starting the live stream, we did a conflict check, and there are no conflicts with our scoring panelists. Teams and coaches are reminded that any disputes arising out of this competition must be reported in accordance with the competition rules. Teams are reminded that compliance with time requirements will be considered in scoring individual performances. I think this is for when we're doing this in person, but no coach or team member is to be seated in the jury box. I would like at this time to have each side introduce their participating team members. Attorneys and witnesses. We'll start with Team FF.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Anna Seaman, and today with my co-counsel, we represent the people of the state of Colorado versus Avery Becker. Today, I will be conducting the direct examination of Detective Markowitz, the cross-examination of Avery Becker, as well as giving the closing argument. At this time, may my co-counsel introduce themselves.
Good afternoon. My name is Leah Dino. I will be conducting the direct examination of Alex Cifuentes and the cross-examination of Taylor Perkins. Thank you.
Good afternoon. My name is Thomas Daneza, and I will be conducting the direct examination of Mr. Kyle Kuzak, the cross-examination of Professor Blake Van Owen, as well as giving the opening statement. At this time, may our witnesses introduce themselves?
Yes, please. Thank you.
Good afternoon. My name is Dirksen Brinkerhoff, and I am Detective Jordan Markowitz.
Good afternoon. My name is Owen Holbrook, and I am Alex Cifuentes.
Good afternoon. My name is Michael Dudzik, and I am Kyle Kuzak.
All right, thank you. Team HH.
Good afternoon, Your Honor, members of the jury, and opposing counsel. My name is Abigail Shapiro, and I, along with my co-counsel, represent the defendant in this case, Mr. Avery Becker. I will be delivering the direct examination of Ms. Taylor Perkins and the cross-examination of Detective Jordan Markowitz. Permission for my co-counsel to introduce themselves?
Yes, thank you.
Good afternoon, Your Honor, members of the jury, and opposing counsel. My name is Evie Angevine, and today I will be delivering the direct examination of Mr. Avery Becker and the cross-examination of Alex Cifuentes, as well as delivering the closing argument.
Good evening, Your Honor. My name is Henry Trembath, and today I will be delivering the direct examination of Professor Blake Van Owen, the cross-examination of Kyle Kuzak, and delivering the opening statement. Permission for our witnesses to introduce themselves.
Yes, thank you.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is William Sharp, and today I am Avery Becker.
Good afternoon, Your Honor, members of the jury, and opposing counsel. My name is Chloe Brantz, and I am Taylor Perkins.
Good afternoon, Your Honor, members of the jury, and opposing counsel. I am Andres Guevara, and I am Professor Blake Van Owen.
All right, thank you, folks. It's now time for me to swear everyone in. I'll start with the team members. If you would please raise your right hands. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
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 Thank you. And witnesses, if you would raise your right hands, please. Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
All right, thank you. And gallery members, I'm not sure if I can see you, but you can probably see me, including teacher and attorney coaches, family members, and friends. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? All right. And scoring panelists, who I think are all hidden at this moment, do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
All right, thank you. I believe that is all of my preliminary comments. And with that, the prosecution may give their opening statement.
Your Honor, may we bring forth some preliminary matters before we begin?
Yes.
Your Honor, we request that the stipulated facts be effectively read into the record and published to the jury.
I'll allow that.
And we request that once exhibits are entered into evidence and shared on the screen, they are also effectively published to the jury.
That's fine.
And we would like to confirm that everyone here has a copy of the exhibits.
Everyone here being the court and the scoring panelists, or?
Yes, Your Honor, sorry, the court and the scoring panelists.
I don't know that I have a copy of the exhibits. I think once they're put on the screen, they'll be effectively published. Is that what you mean?
Would you like us to share them beforehand while we are entering them into evidence so that you can see what we were referring to?
I think the way we'll do this is that you can share them while you're attempting to admit them, and we'll presume that the jury can't see the exhibit. I think that's probably going to be the easiest way to go about it, and that way your witnesses can see it. It's essentially equivalent to walking up to the witness and handing it to them, but we will presume for the purposes of our exercise today that when you're showing it on the screen that the jury's not seeing it until it's admitted. Okay?
Yes.
All right, very good. Go ahead.
We request that any remaining time on closing be reserved for rebuttal.
All right. Noted. Thank you.
No further from the prosecution.
All right. Anything preliminarily from the defense?
Yes, Your Honor. The defense asks that while exhibits are being screened for the purposes of authentication and no lawyers or witnesses are speaking, that time be paused in order to mitigate any technical difficulties with the screen sharing.
So you mean while you're putting it up onto the screen?
Yes, Your Honor, while no lawyers or witnesses are speaking.
Okay, that's fine. I'll allow that.
Thank you, Your Honor. The defense has nothing further.
All right. Thank you both. All right, prosecution, go ahead.
May I proceed, Your Honor?
You may proceed with your opening statement. Thank you.
Good afternoon. My name is Thomas Dineza. Today, my co-counsel and I represent the people of the state of Colorado against Avery Becker. Everyone has a breaking point, and we are here today because Avery Becker reached his. On the day of March 6th, 2020, Mr. Becker broke into the home of Mackenzie Brackman, and while inside, stabbed and killed him. Mackenzie Brackman was an attorney. He spent his entire life fighting for justice. He was a coach. In his free time, he poured hours into teaching young students at Colorado High School what it meant to be an attorney in a competition called mock trial. One of these students was Avery Becker. Now, Mr. Becker was a part of this team for all 4 years of high school. And during these 4 years, Mr. Becker poured plenty of effort and time into the competition. However, Mr. Brackman always perceived his lazy attitude and poor judgment of competition, causing a tension to grow between the two. As this tension grew, Mr. Becker began to crack. One day at practice, Mr. Becker lashed out at his coach and vandalized his car, causing Mr. Becker to be removed from the team. This only caused the rage inside of Mr. Becker to grow. And in his own words, he would get back at Brackman if it were the last thing he did. On the day of March 6th, Mr. Becker reached his breaking point, breaking into the home of Mackenzie Brackman and killing him. The prosecution will call 3 witnesses today. First, the prosecution will call Detective Jordan Markowitz. Detective Markowitz is a detective for the Denver Police Department, and he will walk you through his investigation of Mackenzie Brackman's death. Through this investigation, he will outline how we can place Mr. Becker at the scene of the crime on March 6th. Next, the prosecution will call Mr. Alex Cifuentes to the stand. Mr. Cifuentes was a student at CHS and a member of the mock trial team along with Mr. Becker. Now, Mr. Cifuentes will testify to the tumultuous relationship that the two held, and he will further show how Mr. Becker truly despised Coach Brackman. Mr. Cifuentes will also testify directly about text messages that Mr. Becker sent threatening Mr. Brackman just prior to his death. Finally, the prosecution will call Mr. Kyle Kuzak to the stand. Mr. Kuzak is a consultant for the Denver Police Department who specializes in the field of crime scene reconstruction. You will hear how the crime was committed, and Mr. Kuzak will further show how Avery Becker is the one responsible. The defense will also call 3 witnesses today. You will hear from the defendant himself, and he will claim that he was nowhere near Mackenzie Brackman's phone and was instead searching for his phone. However, you'll hear the same threat that Mr. Becker made towards Brackman in the text messages to Mr. Cifuentes was repeated in a conversation between Mr. Becker and his mother. The defense will also call Taylor Perkins to the stand. Perkins reports to be Becker's alibi, but let's not forget, Ms. Perkins is Mr. Becker's best friend and said herself that she would do anything for Mr. Becker. The defense will also call Blake Van Owen to the stand. Professor Van Owen will tell you about his own personal investigation. But listen carefully. All of Professor Van Owen's so-called evidence is inherently biased towards the police department. In addition, he himself neglected to investigate all of the possibilities of the crime, likely fearing what he might find: the truth. Mr. Becker is being charged with first-degree murder and second-degree burglary. This means that Avery Becker unlawfully and knowingly broke into the home of Mackenzie Brackman and during the invasion, killed him. As the court will instruct you, Mr. Becker did not need to have the intent to kill Mr. Brackman, but the intent to break into his home. After hearing all of the evidence, there will be no doubt that Avery Becker intended to break into the home of Mackenzie Brackman and during the invasion, killed him. Avery Becker had hit his breaking point. The prosecution asks that you reach the only logical verdict for today's trial. Guilty as charged. Thank you.
Thank you. Opening statement for the defense, please.
May I proceed, Your Honor?
You may. Thank you.
Unfortunately, we will never know who really killed Coach Brackman. And the reason for that is because of a fatally flawed police investigation. An investigation that failed to gather critical evidence and investigate the more likely suspects. And because of that, the real murderer is still on the loose. Now, this case is a puzzle. And unfortunately, the prosecution is only providing some of the pieces. But even with the pieces provided, this picture is one of innocence. Today, the prosecution is trying to prove that a high school mock trial student, Avery Becker, would burglarize their coach's house and in the process murder him as a result of a petty verbal argument. The prosecution will not be able to prove that. They will not be able to prove that Avery Becker had anything to do with this crime. Now, Avery and Brackman had their differences in the past, yes. Avery had overreacted in past situations. But making dumb decisions is the thing that many teenagers do. However, the jump from a petty disagreement to a home invasion and murder is absurd. Avery wanted to heal his relationship with Brackman. He wanted to get back on the team. And it is impossible that Avery Becker was even at Brackman's house on March 6th because he was with Taylor Perkins the entire day. Taylor, a fellow mock trial student, will tell you that Avery picked her up in the morning and they spent the day looking for Avery's lost phone. Taylor was with Avery when they found out about Brackman's death. Avery Becker will tell you the exact same story. Now, the prosecution's case only works if you come to the conclusion that both Avery Becker and Taylor Perkins are blatantly lying. And the two pieces of so-called evidence that the prosecution relies on to place Avery at the scene are alleged text messages and cell tower data. And these are both far from conclusive. First, Detective Markowitz based his investigation almost exclusively on alleged text messages provided by Alex Cifuentes that he claims are from Avery. But Alex and Avery were not close friends. They weren't even friends at all. Alex was even jealous of Avery's stardom on the mock trial team. And it would make no sense that Avery would confess incriminating plans to a random acquaintance. And given the importance of these text messages, the police could have and should have downloaded the actual messages rather than relying on alleged screenshots. However, they failed to do this. And as a result, there will be no other conclusion for you to reach than these messages are fraudulent. Secondly, the prosecution relied on cell tower data, more specifically, Avery's cell phone tower data. Detective Markowitz will claim that this data is proof Avery's phone was in a 6-mile radius of Brackman's house. But Professor Van Owens, he'll show you a glaring flaw with this conclusion. Phones don't always connect to the nearest tower. If the tower is busy, the phone will connect to another one. It's as simple as that. And even if this data did track the phone, it wouldn't be tracking Avery because he lost his phone the night before. Taylor and him were looking for it the entire day. Now, the police not only failed to investigate any other suspect, but more significantly, they failed to investigate an obvious one, Blair Rollins. Blair's father threatened Brackman's life for poor representation in a trial that led to a life sentence with no parole. Blair was not in school the day of the murder. He matches the build of the person in the security video, and coincidentally, Blair has disappeared since the murder. Kyle Kuzak will describe to you what supposedly happened on March 6th. She'll tell you they found evidence of a break-in and murder, which no one denies. But what she didn't find was any conclusive evidence that Avery was the perpetrator. No fingerprints, no DNA, no hair strands, no videos or photos of Avery's face, and no eyewitness claiming they saw Avery at the scene. She came to the conclusion it was Avery without physical evidence. Kyle Kuzak will even confess that she wished she had more physical evidence. Her conclusion is an assumption, and you will see that the prosecution's case is full of them. At the end of the trial, you'll see that all of the evidence presented and all of the evidence missing, all of these create a picture of innocence. There is reasonable doubt. You cannot send an innocent person to jail based on assumptions and maybes, and those have underlied the prosecution's entire investigation. You cannot find Avery Becker guilty. Thank you.
Thank you, counsel. Prosecution, you may call your first witness.
The prosecution calls Detective Markowitz.
Go and raise your right hand for me, please. Do you swear or affirm under penalty of perjury the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. Go ahead, counsel.
Good afternoon, Detective Markowitz. Please state your name and spell your last name for the record.
Jordan Markowitz, Markowitz.
And what do you do for a living?
Well, I'm a homicide detective with the Denver Police Department.
How long have you been working there?
I've been working for the DPD for around 7 years, specifically a homicide detective.
And do you have any other certificates or certifications?
Absolutely. I have a certification in cell phone technology and forensic data recovery from the American Academy of Law Enforcement.
What did you have to do to get this?
I had to take a 3-day training course and then complete a high-level certification test.
Have you ever used this knowledge in your investigations?
I've worked with the certification in over 50 cases of detective work.
And were you asked to give an expert opinion in today's case?
Yes.
Your Honor, I now move to enter Detective Markowitz as an expert witness in the field of crime scene investigation, cell phone technology, and forensic data recovery.
Any objection?
No objection, Your Honor.
All right. The detective will be an expert in the areas as outlined by the prosecution. Go ahead, counsel. Thank you.
Now, Detective Markowitz, you said you came to an expert opinion. What was that opinion?
Yes, it is my opinion that the defendant in this case, Mr. Becker, broke in and killed Mr. Brackman within his own home on March 6th of 2020.
How are you first involved in this?
I first became involved in this case when a passing motorist reported a supposedly passed out body on the porch of 444 South Flower Street.
Did you recognize the victim?
Not at first upon arriving at the scene, but once I checked his ID, I did recognize the victim as Mackenzie Brackman.
And did you take photos of the body as you saw it?
Yes.
Would you recognize those photos if they were shown to you?
Yes.
Please turn your attention to Exhibit 2. What is this?
This is a photo of Mr. Brackman's body showing the specific angle and location of it specifically. And you can also see that Mr. Brackman is lying face down in a pool of blood.
Is this a fair and accurate depiction of what you saw at the crime scene?
Yes.
Your Honor, I now move to enter Exhibit 2 into evidence.
Any objection?
No objection, Your Honor.
All right. The exhibit will be admitted. Thank you.
What did this image and the position of the body show you?
Well, specifically, as you can see, it looks like Mr. Brackman is trying to flee the scene. It is my opinion that Mr. Brackman was stabbed within the exterior of the home and attempted to flee. However, before he was able to escape his own house, he collapsed face down in a pool of blood, as we can see in Exhibit 2.
Did you observe the weapon of attack?
I did. I observed the weapon of attack was a large chef's knife.
And after viewing the body, what did you do next?
Next, I walked around the exterior of the home towards the back of the house.
What did you see on the exterior of the home?
Here, I saw 3 different Ring doorbell security systems, specifically their motion sensor activated cameras.
And did you analyze the footage from these cameras?
I did. Upon downloading the contents from Mr. Brackman's phone, I found 4 different videos of an intruder breaking and entering into Mr. Brackman's home on, again, March 6th of 2020.
And please turn your attention to Exhibit 12. Now, what is this video?
This is a video of the intruder entering through the back door of the home wearing a hoodie, mask, and gloves.
Is this a fair and accurate depiction of the video that you viewed in your investigation?
Yes.
Your Honor, I now move to enter Exhibit 12.
Any objection?
No objection, Your Honor.
All right, the exhibit will be admitted. Thank you.
Now, after viewing this video, what did you do?
Next, I entered through the same door, the back door of the home, and went into the living room of the house.
What did you see there?
Upon entering the living room, I observed a scene that was in slight disarray. There was a toppled over chair and a broken plate on the floor. Then in the kitchen, next to the living room, there was an empty slot in the knife block and an open knife drawer.
Did you observe any blood at the scene?
I did. I observed blood droplets leading from the kitchen area to the front door, as well as apparent blood spatter on the wall and ceiling near the victim's body.
And based on all of this evidence and what you investigated, what did you conclude about what happened at the house?
It is my opinion that Mr. Brackman was somehow alerted of an individual entering his home and was killed in this circumstance.
Now, after viewing the home, what did you do?
Next, I turned back to the evidence that I downloaded from Mr. Brackman's phone, and I sifted through copious numbers of emails and text messages relating to Mr. Brackman's work as a mock trial coach for Colorado High School.
Did you investigate this further?
I did. I obtained the contact information of all of the students that Mr. Brackman coached, and I contacted a Colorado High School student by the name of Alex Cifuentes.
What did you learn from Mr. Cifuentes?
Mr. Cifuentes notified me about an apparent text message threat against Mr. Brackman and his home.
Did you ever learn who this threat was from?
I did. This threat was from the defendant in this case, Mr. Avery Becker.
And did you view these text message screenshots in your investigation?
Yes.
And would you recognize a copy if shown to you?
Yes.
Please turn your attention to Exhibit 14. Are these the screenshots that you viewed in your case?
They are.
And who are these text messages between?
These are between Mr. Avery Becker and Mr. Alex Cifuentes.
Are these a fair and accurate depiction of the text messages that you reviewed?
Yes.
Your Honor, I now move to enter Exhibit 14.
Any objection?
I do object, Your Honor. And as you may know, the mock trial rules do not permit me to voir dire an exhibit. Therefore, I would ask that the decision to admit Exhibit 14 be deferred until after I've had the opportunity to cross-examine this witness about this exhibit.
Any response?
Your Honor, no authentication objection has been raised, and the authenticity of this exhibit has been spoken to by Detective Markowitz, and therefore a voir dire is not necessary for it to be entered into evidence.
All right, thank you. I'll note your objection, counsel. I am going to admit the exhibit at this time. You can certainly cross-examine when it is your turn. Thank you.
Yes, Your Honor, thank you. Excuse me, Your Honor. I would ask that the scoring panelists and yourself take judicial notice that this exhibit represents screenshots of the text messages and are not an exact copy of the screenshots themselves.
Response, Your Honor?
Any response, Ms. Seaman?
Yes, Your Honor. These screenshots do show the actual text messages, so a judicial notice is not necessary for this exhibit. This exhibit can be cross-examined and questioned by opposing counsel, but putting a judicial notice right now is not relevant to this case, and the proper questions have not been laid that any authenticity claim or question has been raised to Exhibit 14.
May I respond,
All
Your
right.
Honor?
Briefly.
Your Honor, the defense does object to the authenticity of these documents. It is the defense theory of the case that these text messages were not in fact sent by our client Avery Becker.
All right. Again, I'll note your objection. It's been admitted. It appears to be a screenshot, so I'll let you cross on it when it's your turn. Thank you. You may proceed, counsel.
Thank you, Your Honor.
Now, Detective Markowitz, what from these text messages stood out to you?
Well, specifically, we can see right here, quote, well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house. And that is from Avery Becker.
And after viewing these, what did you do?
Next, I attempted to get an interview with Avery Becker, but I could not. Then I obtained a court order for Ms. Becker's account detail records upon not being able to obtain her phone.
And what did these account detail records show you?
These detailed records showed me that Mr. Becker did go to Mr. Brackman's house on March 6, 2020.
And what came from these records?
Well, specifically, call detail records. And if you'd like me to explain a call detail record allows me, a detective, to see whether a individual is placing a text message or phone call. And upon this, I can then track a cell tower and even the specific cell tower antenna that this communication is making. And then from there, I can pinpoint an individual's phone location.
And did you make a graph or a map of these CDRs?
Yes.
Please turn your attention to Exhibit 15. Is this the map that you analyzed in your investigation of the call detail records?
Yes, it is.
And is this a fair and accurate depiction of that map?
Absolutely.
Your Honor, I now move to enter Exhibit 15 into evidence.
Any objection?
No, Your Honor.
All right, the exhibit will be admitted. Thank you.
Now, Detective Markowitz, can you please show us where Ms. Becker's home is?
Absolutely. This is one of the apparent routes that Ms. Becker could have taken. I will draw it on the screen for you. We can see Ms. Becker's house here, taking this here, going down here, left here, and then arriving here at Mr. Brackman's home.
And how could you tell this?
I could tell this by, again, the specific antenna that the tower is upon, and as well as multiple calls and text messages from another individual that I later discovered was Taylor Perkins.
Your Honor, I now move to enter what has been marked up as Exhibit 15 as Exhibit 15A into evidence.
Any objection?
No, Your Honor.
All right, the exhibit will be admitted. Thank you.
Now, Detective Markowitz, after viewing all of this information and going through your investigation, what did you finally conclude on what happened before and around the time of March 6th?
Based on the call detail records, the evidence at the crime scene, and all of the other evidence collected in this case, it is my expert opinion that Mr. Becker went to Mackenzie Brackman's house on March 6, 2020, and killed Mackenzie Brackman in a confrontation.
No further questions, Your Honor.
Thank you. Cross-examination.
Yes, Your Honor. May I proceed?
Yes, go ahead. Thank you, counsel.
Good afternoon, Detective.
Good afternoon.
Cell phones play a major role in your procedures as a detective.
Absolutely. As I have noted, it is a core part of all of the procedures that I have done in the past 7 years as a detective.
Thank you. And obtaining the contents of cell phones is extremely important to your criminal investigations.
It is. I specialize it, in fact, and have specialized training.
And you have downloaded the contents of literally hundreds of cell phones for prior cases.
This is correct. And as I've mentioned, I have analyzed these in over 50 cases.
And you do that because it is the best practice.
Absolutely.
Now, Detective, Alex Cifuentes did not bring his phone to his interview with you.
No, he did not. He said that he forgot it.
Right. And you thought this was strange.
At the time, yes, I do admit that it is strange, but as I admitted then as well, stress can make people do things that they wouldn't normally.
Yes, but detective, you had never seen a teenager go anywhere without their phone.
Well, I do not have children or family of my own that are teenagers. I did not specifically say that I've never seen that, but yes, it was slightly suspicious. I do have to admit.
And detective, you never saw Mr. Cifuentes' phone.
No, I asked him to send me the screenshots of the apparent text message after our interview.
And so you did not see his phone on the day of the interview, and you have not seen it since.
No.
Now, you claim that Exhibit 14 are screenshots of Mr. Cifuentes' phone.
Yes, allow me to turn to Exhibit 14.
That won't be necessary. I will not be cross-examining you on the contents of Exhibit 14. Thank you. Now, detective, you did not take these pictures.
I did not. I believe Alex Cifuentes took these pictures, sent them to me, and then I conducted an investigation based on these photos.
Thank you, detective. A simple yes or no will suffice. You did not take these pictures.
No, I did not take these pictures.
You never saw the contents of Exhibit 14 directly on Mr. Cifuentes' phone.
In front of me, no. Through screenshots, yes.
Now, detective, these screenshots don't include the date and time in which they were sent.
Date and timestamp, no.
Yet, despite this missing information, you never downloaded the contents of Mr. Cifuentes' phone.
Based on the call detail records that I analyzed off of this evidence, I didn't feel that there was a need to check the validity of this, as the validity was proven through my call detail record analysis.
Thank you, detective, for your answer. In the interest of time, I would appreciate a yes or no answer. You never downloaded the contents of Mr. Cifuentes' phone.
No.
So you are relying on Mr. Cifuentes' word that these screenshots are legitimate.
Mr. Cifuentes' word and my investigation with the CDRs that pertain to this image.
Now, you got the contact information for every student on the mock trial team.
I did.
And you happened to call Mr. Cifuentes first.
That is what I state, yes.
Now, there are other members of the mock trial team other than Mr. Cifuentes and Mr. Becker.
Yes.
In your written report, you do not mention conversations with those other team members.
In my statement, I do not specifically mention that, but if you'd like me to expand on that, on the other individuals on that list, I would be happy to, but it is not within my statement.
Thank you. Now, detective, you are aware that Taylor Perkins, a member of the mock trial team, claims that she was with Mr. Becker on March 6th.
I do, yes.
Now, this is information that could exonerate Mr. Becker.
Not necessarily, but.
Now, you never sought out evidence to corroborate Miss Perkins's story that Mr. Becker was with her.
No.
You never obtained Miss Perkins's phone.
I did not. Again, the timestamps on all of the call detail records that I obtained pinpointed the location of Miss Becker of her phone to Mr. Brackman's home. I do not rely on coincidences as a detective. In all of my experience, I have never relied on coincidences in this case.
Thank you, detective, but that was not my question. You never downloaded the contents of Miss Perkins's phone.
Not Miss Perkins's phone, no.
Detective, I want to transition to cell towers. Cell towers can track phones.
Absolutely.
But cell towers can never track people.
Not people, no.
And cell phones can connect to the closest tower.
Yes, and in fact, through my work, I can obtain the location of the cell tower and the antenna that an individual's phone connects with.
But sometimes a cell tower gets busy and a phone connects to a tower further away.
Sometimes, yes. However, in this case, I know the exact cell tower and the exact cell tower antenna that Mr. Perkins' phone contacted on the day of Mr. Brackman's murder.
Thank you, detective. I want to transition to photos that you took at the crime scene. Now, photos are very important.
They are.
Photos can be more accurate than memories.
In some circumstances, yes.
And other experts and people rely on photos in reaching their own conclusions.
Yes.
Now, you did not bring all of the photos that were taken at the crime scene to court today.
Some of the photos that I took at the crime scene were corrupted images.
Right. Images of blood spatter.
Yes.
Now, you mentioned on direct examination that blood spatter is a part of what you noticed at the crime scene.
Yes, it is what I noticed. However, I did forget to mention I am not an expert in blood splatter, but I have been around, again, many cases. I've been a homicide detective for 7 years to notice blood spatter, specifically cast-off marks.
Thank you, Detective. But the jury today will not be able to see these pictures of blood spatter.
Sadly, no. Due to a faulty system software, they will never be able to see the corrupted images.
These photos are gone forever.
It is true.
Now let's take a closer look at the evidence we do have. I would now ask my timekeepers to please screen share Exhibit 1. Detective, do you recognize this image?
I do.
Is this one of the photos that were taken at the crime scene?
Yes.
The defense now moves to admit Exhibit 1 into evidence.
Any objection?
Yes, Your Honor. On cumulative, a photo of the body has already been entered into evidence, so entering another would be cumulative evidence.
Any response?
Yes, Your Honor. May I tender an offer of proof?
Sure.
Exhibit 1, and I will later try to admit Exhibit 4, are very important because of the exact positioning of the camera and the body, and I would like to cross-examine this witness on those two things.
All right, I'll note your objection, counsel. I am going to admit this exhibit. Thank you. Go ahead.
Thank you, Your Honor. Now, Detective Markowitz, Mr. Brackman's arm in this photo is bent.
It is.
And his hand is located above his head.
Yes.
Now, can my timekeepers please transition to Exhibit 4? Detective, do you recognize this picture?
I do.
Is this one of the photos that were taken at the crime scene?
Yes.
The defense now moves to admit Exhibit 4 into evidence.
Any objection?
No objection, Your Honor.
All right, this exhibit will be admitted. Thank you. Go ahead, counsel.
Thank you, Your Honor. Now, Detective Markowitz, in Exhibit 4, Mr. Brackman's hand is not located above his head. Is that correct?
I do have to admit that the victim's right hand does look like it is in a slightly different position. If you'd like me to explain why I think that would be the case, I would like to.
That will not be necessary. I would appreciate just a yes or no answer. The victim's arm was moved.
The victim's arm does appear to have looked like it's in a different position, yes.
Thank you, Detective. Now, in your own words, good police work requires that you follow up on all leads.
Absolutely.
So let's talk about the leads that you didn't follow. Could my timekeepers please again share Exhibit 4? Detective Markowitz, would you agree that Mr. Brackman is wearing a ring?
Yes.
On the ring finger of his left hand?
Yes.
Objection, Your Honor. Relevance?
May I
Any
respond?
response, counsel?
Yes. Your Honor, it is the defense's theory of the case that this has been a flawed investigation that cannot lead to the conviction of Avery Becker. This includes the fact that Detective Markowitz did not follow up on many leads, one of which could include Mr. Brackman's personal life.
Response, Your Honor.
Ms. Seaman, any reply?
Yes, Your Honor, a ring on the finger does not show that Detective Markowitz didn't follow up on another lead and therefore is not proving a fact of this case to be more or less probable under Rule 401.
All right, I'm going to overrule the objection, counsel. You may ask the question. Go ahead.
Thank you, Your Honor. Timekeepers, you may stop sharing the screen. Thank you. Now, Detective, you didn't mention whether or not Mr. Brackman had a spouse.
I never discussed this within my statement, no.
You didn't investigate whether this spouse might be a suspect.
Again, I never discussed this specific idea or piece of evidence in my statement. Would you still like me to answer the question?
That is not necessary, thank you. Now, Detective, you also suspected that the murderer could be a disgruntled ex-client.
Before reviewing the evidence in this case, yes, as I say, I always consider every possible suspect.
Thank you. But Detective, your report does not include any actions in pursuing an ex-client as a suspect.
Pursuing the client, no. I just include all of the evidence that I believe to point to the, in my expert opinion, to point to the perpetrator in this case and the murderer, Mr. Brackman.
Detective, in your report, you don't even mention the name of any of Mr. Brackman's ex-clients.
I do not know.
Thank you, Detective. Thank you, Your Honor. I have no further questions at this time.
Thank you. Any redirect?
Yes, Your Honor. Now, Detective Markowitz, you were asked about blood splatter on cross-examination. Was blood splatter the only thing that you analyzed in your investigation of the crime scene?
No, it was not.
What else did you investigate?
Again, at the crime scene, there was different videos. A scuffle occurred, broken plate on the floor, a toppled over chair. There was obviously a commotion within the household, knives, tons of other evidence that was not mentioned.
And you were also asked about the movement of an arm. Can you please explain what happened in that instance?
Absolutely. It is a known fact that forensics teams are allowed to reposition the body upon taking photos. So that's what I assume happened. Again, I walked away from the body and pursued my investigation after arriving at the scene.
All right, thank you. Any response, Ms. Seaman, to the speculation objection?
Yes, Your Honor. Detective Markowitz is an expert witness in crime scene investigation. He would understand the happenings around this investigation and what would occur with his forensic team. So he would not be speculating on this fact.
Any reply, Ms. Shapiro?
Yes, Your Honor. I believe that the witness's exact wording was, "I would assume." This wording implies a speculative answer.
All right, I'll note your objection. I'm going to overrule it. He has been qualified as an expert. You may continue, Ms. Seaman.
Yes, Your Honor.
Detective Markowitz, can you continue your statement from before?
Absolutely. Throughout crime scene investigation, bodies are moved in order to get better angles of a wound or just a victim's position. And again, I did not see this exact movement because I walked around the exterior of the home and investigated the outside of the house and other areas of the crime scene.
And you were also asked about any other suspects. What did you analyze to have you come to Ms. Becker or Mr. Becker as the suspect in question today?
Well, I would have considered the validity of these text messages if the CDR data did not point me to Mr. Becker. Due to these CDR data, I can conclude that all of the strings of apparent text messages between Taylor Perkins and Mr. Becker directly match up with Mr. Becker's location from his house driving to Mr. Brackman's house directly before Mr. Brackman's murder.
No further questions, Your Honor.
Thank you. Any recross?
No recross, Your Honor. Thank you.
All right, thank you. Prosecution may call your second witness.
The prosecution calls Alex Cifuentes. May I proceed, Your Honor?
Mr. Cifuentes, go ahead and raise your right hand for me, please. Do you swear or affirm under penalty of perjury the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, counsel, your witness.
Please state your name and spell your last for the court.
My name is Alex Cifuentes, Sifuentes.
Do you currently attend high school?
Yes, I'm currently a senior at Colorado High School.
And do you know the defendant, Avery Becker?
Yes, me and Avery went to Colorado High School together, and we were both on the mock trial team together.
And did you know Mackenzie Brackman?
Yes, Coach B, he was our mock trial coach ever since I was a freshman.
From your personal observations, what was the relationship between Coach Brackman and Mr. Becker like?
It was always critical. There was always criticism from Coach Brackman, and they were always frustrated with each other.
And how would Mr. Becker react to said criticism?
Avery never took it well. It was always not good.
I'm going to ask you a couple questions concerning the regional tournament last year. How did the defendant do at said tournament?
Avery did pretty well, skating by, but Avery won Best Attorney Award and Best Closing Argument Award, which I mean, an award for Avery is an award for all of us.
And after regionals, were there any further disagreements between Coach Brackman and the defendant?
Yes, there were. Right after the regional tournament and Avery winning his awards, Coach Brackman told Avery that what he was doing would be considered malpractice in the real world.
And how did Mr. Becker react to that?
Avery was infuriated. He had definitely reached.
Any response, Ms. Dino?
Yes, Your Honor. The witness was present at the time of this argument. Therefore, Mr. Cifuentes did see how Mr. Becker exactly reacted to the statements made by Coach Brackman. Therefore, he's not speculating at all.
All right, Ms. Angevine, any reply?
Your Honor, there has been no foundation laid to show that this witness would know how Avery Becker was remotely feeling in this situation, so it is speculation.
All right. He can testify to his observations. I'm going to overrule the objection. Thank you. You may go ahead, counsel.
Mr. Cifuentes, can you continue on your description of what happened?
Yes, Avery was visibly enraged, and Avery, on his way out the door in a fit of anger, took one of the Sharpies off of the easel of paper and wrote Worst Attorney Award all over Coach's beautiful 1986 Porsche 911.
Objection, improper character evidence.
Ms. Dino, a response?
Yes, Your Honor. No character trait of Mr. Becker's is being used in this testimony, and it is not being used to show that he acted in conformity with that character.
Thank you. Ms. Angevine?
Your Honor, this evidence is showing that he vandalized a car, which would then he vandalized a house, which is improper in character evidence. And if they're not using it to show that he acted in accordance, then I would say that under Rule 403, this evidence is unfairly prejudicial.
All right. I'll note your objection. I'm going to allow the testimony. You may continue, counsel. Thank you.
Mr. Cifuentes, how do you know what kind of marker Mr. Becker used?
It was obvious that we keep the Sharpies on next to easel of paper where we write our trial ideas, and they look nothing alike.
And do you know if Mr. Becker had a consequence to this vandalism incident?
Yes, Avery was kicked off the TNN team, and I'm surprised Coach didn't press criminal charges.
And after the vandalism incident, did you hear from the defendant?
Yes, Avery texted me asking if I would talk to Coach Brackman on his behalf.
And did you talk to Coach Brackman as you were asked to?
Yes, I did.
And what did Coach say?
Coach said that he wasn't going to back down.
What was the defendant's reaction when you told him this?
Avery had become infuriated again.
Your Honor, permission to share Exhibit 14. It has been previously admitted. After you said that you doubt anyone.
Go ahead, you're fine. Sorry, I didn't get to my mute button quick enough.
No worries, Your Honor. After you said you doubt anyone could change the coach's mind, what did the defendant say?
Avery said, well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house.
Did you respond to that?
Yes, I asked him, what are you going to do to his house?
And what was the next thing that Mr. Becker said?
Avery continued on and said, I'm going to wait until he's at work and then break in and trash it. That'll show him.
Did you respond to that text?
Yes, I said that I don't think that's a very good idea.
Thank you. That'll be all for the screen sharing. After Coach Brackman was murdered, did the police ever contact you?
Yes, a police officer, Detective Markowitz, contacted me.
And did you meet with the police in person?
Yes, after I talked on the phone with him, I was asked to come to the station for a full interview.
Did you have your phone with you that day?
No, the battery wouldn't hold a charge, so I left it at home on the charger on accident.
Did the police ever see these text messages?
Yes, I emailed exact copies to Detective Markowitz.
Are the copies of the text in Exhibit 14 what you sent Detective Markowitz?
Yes, they are.
Were you at the Fry Shack on Thursday, March 5th?
Yes, me and some of the other mockers like to go there sometimes.
And did you see the defendant there?
Yes, Avery was there.
Did you see if Mr. Becker had his phone with him?
Yes, Avery did have his phone at the Fry Shack.
And did you ever come in contact with him?
Yes, I played a new game on Avery's phone.
Did you end up taking the defendant's phone?
No.
Did you alter his phone in any way?
No, I'm no Bill Gates.
Do you know of a person named Blair Rollins?
I know of Blair Rollins, but that's the extent of it.
Are you friends with Mr. Rollins?
No.
And did you give the defendant's phone to Blair Rollins?
No, I didn't know Blair that well in the first place, so why would I give him someone else's phone?
You said that Mr. Becker was an excellent attorney at mock trial. Was he also a good witness?
Yes, Avery was talented and got the spotlight from being an attorney, but if you put Avery on the witness stand, he could sell anything.
Thank you. No further questions.
Cross-examination.
Yes, Your Honor. Good afternoon, Mr. Cifuentes.
Good afternoon.
So the day after Mr. Brackman died, a detective called you.
Yes,
He wanted to meet.
yes, I was asked to come in to give a full interview.
Right, and you knew this meeting was important.
I mean, I got a call from the police, and when you get asked to come in, I feel like it is pretty important.
He told you he wanted information.
Yes. Over the phone, I reported the text messages, and that's when I was asked to come in.
And you wrote up a report in this case, is that correct?
Can you ask the question again? Sorry, you cut out.
You wrote up a statement in this case?
Yes, I did.
You didn't write that you were nervous about going to see the detective in this statement.
No, I didn't.
You didn't write that you were stressed out?
It's kind of a natural thing when the police call you.
You didn't write that you were stressed in this statement?
No, I did not.
You claim your phone contained texts.
Yes, Avery texted me.
Texts that you're telling the jury are very important.
Yes.
You knew you wanted to discuss these texts with the detective.
Yes, I mean, I heard Coach Brackman had died.
But you didn't bring your phone.
I left it at home on the charger because my battery wouldn't hold a charge anymore.
Right, you were charging it.
Yeah, it was a complete accident.
You were charging it because you wanted it to be fully powered for the meeting.
Yes.
You didn't turn around and go get your phone.
No, in the spur of the moment of my dad yelling at me that it was time to go, I had left it on the charger.
You claim Avery sent these texts.
Yes, Avery did send these texts.
And you showed Detective Markowitz the texts through a screenshot.
I emailed them to him, yes.
Detective Markowitz never asked to see the text on your real phone.
I offered to bring my phone in.
But he said you didn't have to.
Yep.
And now the phone is gone.
Yeah, I traded it in because it wouldn't hold a charge anymore, and I got a new phone.
So the only evidence of these texts is the screenshots.
Yes, and they were given to Detective Markowitz.
And there are no timestamps on these screenshots.
And I can't see the exhibit right now, but to my recollection, no, that there were no timestamps.
Moving to mock trial's a lot of work.
Yes, it is.
You would spend hours practicing.
Yes, I would.
Avery didn't do that.
Avery came up with stuff on the fly.
That bothered you.
Yeah, personally, it did a little bit.
You scored pretty well in the competitions.
Yes, I did.
So did Avery.
Avery won the awards.
You didn't think he deserved to win those, did you?
I thought that my work had been better reflected, but Avery still won them.
Now, you never hung out with Avery outside of mock trial.
No, the only time we really got to hang out was in mock trial.
And moving to Blair Rollins, you knew that Brackman represented Blair's father in a criminal case.
No, I didn't. I knew that Mr. Brackman had represented a student's father.
But you know who Blair Rollins is.
I know of him.
Detective Markowitz never asked you any questions about Blair Rollins.
No, he didn't.
Never asked you any questions about any other witness.
No, I reported those text messages about Avery.
He never asked you about anyone other than Avery Becker.
I mean, I reported the text messages, and that's all I know about that.
But Detective Markowitz never asked you about any other suspects aside from Avery Becker.
Objection, Your Honor, asked and answered.
Your Honor, response, Your Honor?
Yep, go ahead.
The witness did not answer my question. I was simply asking for a yes or no, and he did not actually state whether Detective Markowitz had asked him.
All right, any reply, Ms. Dina?
The witness did answer. He said all he asked me about was Avery Becker.
All right, I'll go ahead and allow it. I'll overrule the objection. Go ahead, counsel.
Would you like me to restate the question, Mr. Cifuentes?
If you would, please.
Detective Markowitz never asked you about any other suspects.
No, he only asked me about Avery Becker.
Blake Van Owens came to see you a couple weeks ago, is that correct?
A private detective did.
And you didn't answer any of his questions.
Well, it was quite apparent that this private investigator worked for the defense, so all they were trying to do was get something that they could use to impeach me.
Right, so you didn't answer any of his questions.
No.
And moving to the Fry Shack, you saw Avery at the Fry Shack the day before Brackman died.
Yes, I did.
You asked to use Avery's phone.
I used Avery's phone to play a game.
You had your own phone.
Yes, I did.
But you asked to use Avery's.
It was Avery's game.
And he let you play on his phone.
Mm-hmm.
So you had access to Avery's phone that day.
Yes, I did.
Thank you, Your Honor. No further questions for this witness.
Thank you. Any redirect?
No, Your Honor.
All right. Thank you, Mr. Cifuentes. Prosecution may call your next witness.
Your Honor, at this time, the prosecution calls Mr. Kyle Kuzak to the stand.
All right, go ahead and raise your right hand for me, please. Do you swear or affirm under penalty of perjury the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, it's your witness, counsel. Go ahead.
Mr. Kuzak, please state your name and spell your last for the court.
My name is Kyle Kuzak, K-U-Z-A-K.
What do you do for a living?
Well, I'm a civilian that sometimes works for the Denver Police Department. I work in the field of crime scene reconstruction as an investigator.
Crime scene reconstruction? What is that?
Well, you heard the testimony of the detective in this case. Now, I work closely with them, but the detective gives me pieces, and I put those pieces together to make a puzzle.
Now, how long have you worked as a CSR?
I've worked as a CSR for 19 years now.
And during your time, what sort of cases have you investigated?
I've worked on all sorts of cases, car accidents, homicides, armed robberies, never one with a mock trial, Coach, but I digress.
Were you asked today to give some excuse me, let me ask one more question. Do you have any certification in the field?
I do. I was board certified by the Colorado Bureau of Investigation 19 years ago when I first started practicing.
Were you asked to give some expert opinions for today's case?
Yes,
Did you reach any?
I did, yes.
Your Honor, at this time I offer Mr. Kyle Kuzak as an expert in the field of crime scene investigation and reconstruction.
Thank you. Any objection?
Your Honor, I have some questions that relate to the qualifications of this witness, but they relate more to credibility, and I'll reserve them for my cross.
All right, then the witness will be qualified as an expert. You may continue, counsel.
Of course. Mr. Kuzak, you mentioned some expert opinions. What were they?
Well, first, I realized that somebody was trying to get into Mr. Brackman's house on March 6, 2020. Now, it wasn't apparent that they were trying to kill him, but once inside the residence, the perpetrator did kill Mr. Brackman.
And before we talk about how, let's talk about your involvement in the case. How did you initially become involved?
Well, I got a phone call from the Denver Police Department, specifically Detective Markowitz. He said that they had some sort of homicide on their hands and that they needed a professional crime scene reconstructionist.
Now, after receiving the call, did you go to the scene of the crime?
Yes, I responded immediately to the scene of the crime, where I took a couple of photos, but more kind of got an overview, started collecting pieces for my puzzle.
Now, once you started that collection, how did you put it together?
Well, I use a 5-step process. It's my CSR case management process.
Could you describe that for the jury?
Absolutely. Now, step 1 is my recognition and documentation. It's when the detective presents the puzzle pieces to me. Steps 2 and steps 3 are my collection and my evaluation of the evidence. I start to look at the corner pieces, put the puzzle together. But step 4, my hypothesis and my testing, is really where I start to analyze those difficult sky pieces that are all the same color. And that's when the picture really comes to light. And step 5 is my ultimate opinion that I use to form for court testimonies or legal documents.
Now, let's talk about the evidence itself. How did the break-in occur?
Well, first, the perpetrator tried to get in through the front door, but then he moved around to the back and entered through the glass sliding door in that video that you saw.
And now, once the perpetrator had entered, what do you believe to have happened?
Well, initially there was some sort of altercation, some sort of scuffle just inside the back door. And then the perpetrator, Mr. Becker, got control of the knife presented to him by Mr. Brackman, and he was able to stab Mr. Brackman in the back.
Now, let's break this all down. You mentioned a struggle. What evidence points towards this?
Well, there's plenty of evidence, pieces that I was presented with that I put together to indicate a struggle. First, there's some scuff marks on the ground just inside the back door, probably made by shoes. Second, there was a knocked over chair near that scuff mark, as well as a broken plate on the ground.
Your Honor, permission to share what has been previously marked as Exhibit 18.
My mute button again. You can go ahead, counsel. Thank you.
Mr. Kuzak, what is this?
Well, this is an image that I actually took. It's those scuff marks that I just mentioned.
And is this a fair and accurate representation of what you saw at the crime scene?
Yes, that's exactly what I saw. That's my picture.
Your Honor, at this time, the prosecution moves to enter Exhibit 18 into evidence.
Any objection?
Yes, Your Honor. This evidence is misleading, as they're saying that this scuff marks came from the day of the murder, but there is no data to support that these scuff marks came from the day of the murder.
All right, counsel, I'll note your objection. I will admit the exhibit. Go ahead.
Mr. Kuzak, what did these scuff marks tell you?
Well, the scuff marks, along with other evidence, indicate there was some sort of struggle between Mr. Becker and Mr. Brackman.
And now, as this struggle progressed, what occurred?
Well, eventually, Mr. Becker was able to get control of the knife presented to him, and he stabbed Mr. Brackman in the back.
Now, let's look at the murder weapon itself. Permission to screen share what has been previously marked as Exhibit 5.
Go ahead.
What is this?
This is a knife. I did not take this picture, but this is the knife at the crime scene.
And is this a fair and accurate representation of what was observed at the crime scene?
This is exactly how it was, yes.
Your Honor, at this time, the prosecution moves to enter Exhibit 5 into evidence.
Any objection?
No objection, Your Honor.
All right, the exhibit will be admitted. Thank you, counsel. Go ahead.
Now, let's talk about the knife. How exactly was Mr. Brackman stabbed?
Well, if you want me to get into the scientific details, Mr. Brackman was stabbed kind of in the upper back, in the just inferior to his scapula. The knife actually nicked the inferior aspect of his scapula and significantly penetrated the aorta, the biggest artery in the body. Now, once the knife was first inserted, it provided some sort of plug. Blood couldn't really get out. But once it was removed by Mr. Brackman, the blood exited his aorta, and he eventually died.
And where was this knife retrieved from?
This knife was retrieved from near Mr. Brackman's body, just by the door.
Apologize, I must have. Where was the knife originally from?
Oh, the knife originally was from a block of knives in the kitchen.
Now, after reviewing all of the evidence, what could you conclude about the death of Mackenzie Brackman?
Well, to me, it looked like somebody was going there to burglarize, perhaps. But once they were met with force, Mr. Becker met Mr. Brackman with force and killed him.
Now, let's move on. Do you know Professor Blake Van Owen?
I do know. I'd rather refer to him as Mr. Van Owen. Unfortunately, I do know of him.
Do you know of any CSR certifications he holds?
I don't really know if he's certified. I know he practices.
To your knowledge, how does Mr. Van Owen go about his CSR investigations?
Well, as he's a private investigator, in my opinion, in the cases I've worked in the field 19 years.
Objection, Your Honor. Speculation.
Any response?
Yes, Your Honor. In regards to the speculation, not only is this based on the witness's rationally based perception, but also using his expertise, he's able to analyze another's work in the field. So he would not be speculating in this regard.
Response, Your Honor.
Any reply?
Yes.
Go ahead, counsel.
He is not qualified as an expert in analyzing others' work, and he does not work with Professor Van Owen. He cannot make any statements on how Van Owen does his work.
All right. I'll go ahead and allow the testimony. I'll overrule the objection. Go ahead, counsel. Thank you.
To your knowledge, Mr. Kuzak, how does Professor Van Owen go about conducting his CSR investigations?
Well, look, I understand that good old Van Owen he's doing his job. But even when the evidence all points to one person, it seems like he tries to arrive at a conclusion and then looks at the evidence. That's what happened in this case, too.
And did you review Professor Van Owen's case for today?
I did, yes.
And how would you describe, and you're aware of his theory, correct?
I don't know if you'd call it a theory, more of a poorly based opinion.
Could you briefly describe his theory for the jury?
Well, Professor Van Owen thinks that Mr. Brackman was just sitting at his table when somebody came up behind him and stabbed him in the back. That's what he thinks.
And why is this not the case?
This is certainly not the case. In my expert opinion, the pieces just didn't fit his puzzle. The scuff marks on the floor, the broken plate, the knocked over chair, the sound that Mr. Brackman would have heard of somebody opening the door that you saw in Exhibit 12, getting a knife and walking across the wood kitchen floor, the pieces just don't fit.
Thank you, Mr. Cusack. No further questions, Your Honor.
Thank you. Any cross-examination?
Yes, Your Honor. May I request a brief time check?
Sure. What's the time on cross, folks? .358 in the chat. Go ahead, counsel. Thank you.
Good afternoon, Mr. Kuzak.
Good afternoon.
Now, you created a timeline of the events of March 6th to come to your conclusion, right?
Yes, sir.
But you were unable to recreate a full timeline of the day.
I was asked to recreate a timeline from the time the perpetrator arrived at Mr. Brackman's front door to the time the perpetrator left.
I'm sorry, you must have misheard my question. You are unable to recreate a full timeline of that day.
A full timeline of the events within Mr. Brackman's home, if that's what you're asking.
Yes, you were unable to recreate a full timeline of the events that unfolded there.
No, I absolutely could. Through my peer review that I do and my hypothesis, a timeline was established.
Not a full one.
I'm sorry.
Answered.
Any
Your
response,
Honor?
Mr. Trembath?
If I may direct the witness to line 130 of his witness statement, he states that he was not able to recreate all event segments, referring to the timeline here.
I'll overrule the objection. I'll let you go down this road a little bit. So overruled. Go ahead, counsel.
Now, Mr. Kuzak, you don't make assumptions in your line of work.
I'm sorry. I'd like to come back to your last question. I don't think the jury understands what I meant when I wrote that down in my witness statement. What I really meant was I couldn't recreate.
Sorry, that wasn't the question I asked right now.
Okay, hold on. Hold on. So in all fairness, Mr. Trembath, you asked him a question about the timeline, and then you impeached him with his statement, but I think he does get a chance to explain what he was talking about. So I'm going to go ahead and let the witness answer your original question about the timeline. Go ahead, Mr. Kuzak.
Yes. So what I was referring to is the blood splatter being thrown on the wall, Mr. Brackman falling out of his chair. We don't know if he, or not falling out of his chair, but involved in a struggle. We don't know immediately where the struggle happened, if Mr. Brackman frantically looked around and then ran to the kitchen, or if he immediately ran to the kitchen. The timeline is not absolutely clear, but I did create a full timeline as to counsel's question.
Yes, it is not absolutely clear. Thank you. But you need evidence to come to a conclusion, right?
Absolutely, yes.
Yes. A conclusion without evidence is an assumption, right?
Exactly. You put it the way I would.
But in this case, you wish that you had more physical evidence at the scene.
Oh, absolutely. In my 19 years of work, I've included that in every witness statement. It's kind of a standard. Nothing's for certain. Things can be very sure, like this case, but I always wish I had more evidence.
Yes. Now, let's go over the ring cam video. You saw the ring cam video.
The Ring doorbell camera, yes.
And you assume that video notified his phone.
Yes, that's how Mr. Brackman was aware somebody was trying to break in.
Yes. But you didn't find a phone on him.
I was not doing the investigation, counsel. I was presented with the pieces and I put the puzzle together.
You were not presented with a phone.
No evidence of a phone was presented to me.
No. So you don't know if the app was downloaded on his phone?
Through my investigation and his actions within the residence, it's clear that he did receive some sort of notification.
But you don't have the phone, so you don't know if he had the app downloaded.
I do not know if he specifically had the app downloaded for certain. No, counsel.
And you don't know if he had his notifications even turned on?
That's a good question. Again, his actions within the residence indicate that he did.
Now, let's talk about this knife. This knife doesn't fit the set of knives that are in the kitchen block.
The block specifically, no.
No. But let's pretend it did. Now, you said that Brackman grabbed the knife.
Yes.
To defend himself from the intruder, right?
Yes, exactly.
And then the intruder and him got into a struggle of sorts.
A confrontation.
Yes. Where Brackman lost the knife.
Not quite. I believe that Brackman was overpowered.
Yes.
Time, Your Honor.
Hold of the knife.
I believe you're out of time, counsel.
All right, no further
Everyone
questions.
agree with? Okay, well, I think he counted you down from a minute to 30 to 10 to 5 seconds, so I think we're going to have to leave it there. Any redirect, Mr. Dineza?
Briefly, Your Honor.
All right, thank you.
Mr. Kuzak, counsel asked you about your timeline. Why is it unnecessary to know every single detail in this regard?
Well, what I was referring to in the witness statement was specific key details. Like if, like I said, Mr. Brackman stood up and looked around, if Mr. Brackman received multiple doorbell notifications or just one. But the timeline is still relatively clear. I just don't have complete evidence. I don't have a video of him doing all this inside of his house.
Now, do you have all the important details?
I have all the important details and more, yes.
Thank you, Your Honor. No further questions.
All right, thank you. Did the people rest?
Yes, Your Honor, the prosecution rests.
Thank you. All right, for the defense, you may call your first witness.
The defense calls Avery Becker to the stand.
Mr.
Hello.
Becker, go ahead and raise your right hand for me, please. You swear or affirm under penalty of perjury the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, your witness, counsel.
Can you please introduce yourself to the jury?
Hello, my name is Avery Becker, and I am a graduate of Colorado High School.
What is your relationship with Mr. Brockman?
Well, I originally joined mock trial with my best friend Taylor, and Coach Brackman was the coach of mock trial.
Did you like mock trial?
I loved mock trial. It was my life in high school. You know, I was a little bit of an oddball, and mock trial was just really where I shone through, so I felt really comfortable there. And it was even better because I got to hang out with my best friend Taylor.
Right. How do you know Taylor?
Taylor's my best friend, like I just said. She actually did mock trial because of me. And we're always hanging out in our free time. So it was just an excuse to spend more time together.
And what did you do on March 6th?
Oh, let's see, March 6th, I woke up and I looked for my phone immediately and I couldn't find it. And then I thought back and I realized I couldn't remember having it after I went to the Fry Shack the night before. So Taylor and I decided to skip school to retrace our steps from the night before. We went back to the Fry Shack and to the mall, but we just couldn't find it.
You mentioned you went back to the Fry Shack. What happened at the Fry Shack the night before?
Well, Taylor and I got hungry, so we decided to go get something to eat. And we got there and the entire mock trial team was there, which was so humiliating because the day before I had been kicked off the team. And I wanted to get out of there as soon as possible. And I guess I was in a bit of a rush and didn't realize I didn't have my phone.
And you mentioned that Alex and the mock trial team were there. How do you know Alex?
Well, I know Alex mainly because of mock trial. He likes to think that we're friends, but we never really got along. He's just really obsessed with competing with me in mock trial. And I do mock trial because I love it.
Objection, Your Honor.
And your response, counsel?
Your Honor, my witness just stated that he knows Alex through mock trial and that he has spent a lot of time with him, so this is rationally based on his perception.
Response, Your Honor.
Any reply, Ms. Seaman?
Yes, Your Honor. Mr. Becker just stated that he didn't really like Mr. Cifuentes, and through his time on the mock trial team, he couldn't know how Mr. Cifuentes felt and how he would have had a competitive spirit or would have done any, or would have competed with him for anything.
All right, he can testify to his observation, so I'm going to overrule the objection. Go ahead, Ms. Angevine.
Mr. Becker, would you like me to repeat the question or are you good to continue?
Could you please repeat the question? I'm sorry.
How do you know Alex?
Oh, yeah, because of mock trial. And we have conflicting personalities, I guess you could say. And we never really talked that much outside of mock trial, which is why it's ridiculous that he's claiming that I texted him. It's just couldn't be further from the truth.
You've heard Blair Rollins mentioned in this case. How do you know Blair?
Blair Rollins went to school at Colorado High School with me. There was actually a lot of drama that went around the school when I was there because Brackman was Blair's dad's lawyer, and he lost the case. And because of that, Blair had a reputation for really hating Brackman.
Objection, Your Honor. Speculation and foundation.
Ms.
Your Honor,
Angevine?
this witness has stated that they knew Blair and went to high school with Blair. Additionally, the witness did not say that he knew that Blair hated Brackman. He said that Blair had that reputation, therefore he's not speculating.
Ms. Seaman?
The foundation has not been laid that Mr. Becker would have known about this reputation or that he knew Blair that well enough to know that he hated Mr. Brackman in this case.
Response?
All right. I'm going to go ahead and allow it. It's overruled. Go ahead, Ms. Angevine.
Thank you, Your Honor. Did you and Blair have any sort of relationship?
No, we didn't really speak to each other that much, but people always confused us because we look really similar.
Did you know if Blair and Alex were friends?
Well, if mock trials taught me anything, it's that I can't speculate, but I've seen them talking in the hallways quite a few times, so I assume that they have a good relationship.
Moving to Mr. Brackman, what was your relationship like with him?
I must say it was a little fraught with tension. He was always picking on me and never thought I did enough work. But I did really well in competitions, and that's what mattered. I didn't hate Brackman, of course not. I was always a little bit frustrated with him.
Did he ever do anything to affect your performance at mock trial?
Yeah, actually he did. About a month before regionals, he was mad again about my lack of preparation, and he decided to put me down to B team, which was a pretty clear demotion. And I was devastated. As I said, mock trial is my life. But luckily, Taylor had no interest in doing mock trial if I wasn't there. So he had to move me back up.
How was mock trial after that?
We did so amazingly at regionals, and I was so happy. I won a ton of awards, which felt great. And we always do this thing after regionals that we debrief the whole case and how it went down. And that's when Brackman just went in on me, and he was screaming at me. And I just wasn't in the mood to be yelled at. So I decided to leave the room and just take a break.
And what happened next?
Well, I was still holding a marker, and I thought for sure that it was a whiteboard marker, and I felt terrible for what I did next, but I wrote on his car, and I regret that so much. But Brackman kicked me off the team once he figured out.
Now, did you ever try and rebuild this bridge with Brackman?
Oh my God, so many times. I wanted more than anything to get back onto the team, and I tried to apologize. I even went to his work. I offered to scrape the marker off of his car. He just wasn't willing to listen.
Why was it so important for you to apologize to him?
Well, I did want to help my team win state. That was a goal of mine. But more than that, I just felt really bad for what I had done. And Brackman didn't deserve that. My frustration shouldn't have been taken out on him that way. And I felt really bad about that.
Mr. Becker, I'm sorry to have to ask you this, but did you have anything to do with Mr. Brackman's death?
No, of course not. I mean, I was with Taylor that entire day. And even more than that, I didn't want to hurt Coach Brackman. I wanted to apologize to him. And it's just ridiculous that I'm being framed for this.
Did you know where Mr. Brackman lived?
No, I mean, we never did practices at his house or anything like that, so I wouldn't know where he lived.
How did hearing about Mr. Brackman's death affect you?
Sorry. I was devastated. The first thing that came to mind was I never got to apologize. And that felt terrible, knowing that the last thing that he thought that I thought of him was that I hated him more than anybody. And that couldn't have been further from the truth.
Thank you, Your Honor. No further questions for this witness at this time.
Thank you. Any cross-examination?
Yes, Your Honor.
All right, go ahead, counsel.
Good afternoon, Mr. Becker. You just stated that mock trial was your life, correct?
Yeah, I loved it.
You thought you were the best on the team.
Well, yeah, I mean, I put a lot of time into it outside of practice actually because it was the only thing I was really good at.
And you hoped to win best attorney in the state, correct?
Yeah, I did want to do that. That was a goal of mine.
But Mr. Brackman stood in your way, didn't he?
Yeah, he was always getting on me for not doing enough work.
And you thought that he hated you, didn't you?
Well, I mean, he was always yelling at me, so I just assumed that he did.
He called you lazy.
Yes.
He rewrote all of your work.
Yeah.
And he even moved you down to the B team.
Yeah, which was preposterous because I won so many competitions for us.
Exactly, and after all of your accomplishments, he said you only won because of your looks, didn't he?
Well, yeah, he did say that, which, I don't know. I don't find myself to be too attractive, so that was a little bit shocking.
But this made you very angry, didn't it?
I would say frustrated. Yeah, I don't like to be told that I'm not doing enough.
And so you took a marker, correct?
Yeah, I thought it was a whiteboard marker.
But it was a Sharpie, wasn't it?
Well, I learned later that it was, and I felt so horrible about this.
And you wrote on his car, didn't you?
Yeah, I did. I feel terrible.
And after this, you went home and talked to your mother, correct?
Yeah, I did.
And you told your mom that you would get back at Mr. Brackman if it was the last thing you did. Didn't you say that?
Objection 4-3, prejudicial and misleading the jury.
Any response, Ms. Seaman?
Yes, Your Honor. This is not, for Rule 403, a statement must be farly more prejudicial than it is probative. And in this case, the probative value of this statement showing that Mr. Becker said that he would get back at Mr. Brackman farly outweighs any prejudicial effect of it.
Ms. Angevine,
May I
any
respond?
response?
Yes, Your Honor, we have no context for this conversation or anything that was said before and or after. Therefore, it is mischaracterizing the evidence and would therefore mislead the jury.
All right, I'll find there's probative value. I'm going to overrule the objection. Go ahead, Ms. Seaman.
Now, Mr. Becker, you told your mother, yes or no, that you would get back at Mr. Brackman if it was the last thing you did. Didn't you say that?
Yes, but I'm sure you said something that you didn't mean in the heat of anger.
But please turn your attention to Exhibit 14. The last statement on that says, I'm going to wait until he's at work, then break in and trash it. Doesn't it say that?
I'm sorry, I cannot see Exhibit 14.
Your Honor, may we please screen share Exhibit 14?
Yes, that's fine. Thank you.
Now it says, the last text from Avery Becker says, I'm going to wait until he's at work, then break in and trash it. Sorry, second to last text.
Yeah, I did not send these texts, so that's completely ridiculous.
But this text is also a threat against Mr. Brackman, isn't it?
Yes, I suppose it is, but I didn't send those texts. I've been trying to tell you I didn't send those texts.
But this text mirrors what you told your mother, doesn't it?
Well, yeah, it certainly does look something like that, but I think this is a
Objection, Your
pretty...
Honor, out of the scope.
Ms. Seaman, any response?
Your Honor, this is cross-examination. I'm allowed to question the witness on evidence that has been entered and on words that he said. And so this is not out of the scope of cross-examination.
Ms. Angevine?
I'm sorry, I meant out of the scope of my witness's expertise, as my witness has testified numerous times minutes ago that he, in fact, did not send these texts, so he is not able to testify on them.
Response, Your Honor?
Well, the witness testified that the text matched the conversation he had with his mother, so I'll allow it. I'll overrule the objection. Go ahead, counsel.
And so, Mr. Becker, these texts mirror what you told your mother, don't they?
Yes, but I'd imagine some other people have said this before. It's not only me who said something like this.
And so you stated that you allegedly lost your phone on March 5th, correct?
I did lose my phone, yes.
But your phone is very important to you, isn't it?
Yeah, I mean, I guess it's my connection to the outside world.
And you even joined mock trial to be on your phone longer, didn't you?
Well, I mean, that was just part of it. It was mostly because of Taylor. But then I ended up loving mock trial so much, so I wanted to stay on it.
And you turn your phone into your mother every night, don't you, before you finish your homework?
Yes, I do.
And so you didn't notice it was missing on March 5th when you were supposed to turn it into your mother?
No, as I said, I was really in a rush, and I didn't notice that I didn't have my phone.
But when you turned your phone into your mother that night, you didn't notice that you didn't have a phone to turn in?
I didn't do it that night, no. I was still processing what was going on back there.
And Miss Perkins is the only one who knows where you were on March 6th, correct?
Who is testifying today? Yes, that is correct.
And she's your best friend, as you stated.
Yeah, we get along really well. We're always together.
He joined mock trial for you?
Yes, that's correct, yeah.
He quit mock trial for you?
No, I mean, she didn't quit it for me. She just wanted to do it with me. So if I wasn't there, there was no point in her staying because she really didn't enjoy it as much as I did.
So your best friend, the person who did all of these things for you, is the only person who knows where you were on March 6th.
As I said, I'm sure there might be other people, but they're not testifying today, no.
Just to clarify, she is the only person testifying today who knows where you were on March 6th.
No, that is correct, yes.
No further questions, Your Honor.
Thank you. Any redirect?
No, Your Honor.
All right, thank you. You may call your next witness.
Thank you, Your Honor.
Thank you, sir.
Your Honor, the defense calls Ms. Taylor Perkins to the stand.
Ms. Perkins, go ahead and raise your right hand for me, please. Do you swear or affirm under penalty of perjury the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, your witness, counsel.
Thank you, Your Honor. Good afternoon, Ms. Perkins. Can you please introduce yourself to the jury?
Hello, my name is Taylor Perkins. I'm currently a freshman at Boulder. It's probably more relevant to say that I'm a former student at Colorado High School, and I competed on our mock trial team.
Why did you join the mock trial team at Colorado High School?
Honestly, I joined to spend more time with Avery.
And who is Avery Becker to you?
Oh my gosh, Avery. Avery is my best friend in the whole world.
Now, did you have any other close friendships on the mock trial team?
Not really. We all spent a lot of time together as a team, but Avery is really my bestie.
And what was the mock trial experience like for you?
Honestly, I kind of always knew that I wasn't going to be the star of the team or anything, but, it was a great experience for me, and I loved seeing Avery succeed. Even despite all of the drama.
Can you tell us a little bit more about this drama?
Yeah. Well, Avery and Coach had this long-standing feud. I personally thought that their little arguments were kind of funny at the beginning, but they just kept escalating. Actually, one practice, Avery came kind of unprepared, and so Coach got so mad about it that he demoted him from A to B team.
And what did you think about Mr. Brackman's decision to demote Mr. Becker?
In all honesty, Avery was pretty unprepared at that practice, but as he later proved at the regional tournament, Avery was the best on our team, and we needed him. Yeah.
And how exactly did Mr. Becker end up getting back on the A team after being demoted?
Well, I made the decision to step down from A team until Coach brought Avery back up, which he did just in time for regionals.
And did Avery and Mr. Brackman have more arguments during mock trial after regionals?
Yeah, they did, for sure. Everything just totally blew up at one practice in between regionals and state. I didn't see it happen. I wasn't there, but it ended with Avery pranking Coach by riding on his car. It went totally wrong, and then Coach kicked Avery off the team for good.
And what did Avery do about this?
He really tried to get back on the team multiple times, but Coach just didn't budge.
Ms. Perkins, I want to transition to the day before the crime, Thursday, March 5th of 2020. What did you do on this day?
Avery came over to my house after I had mock trial because, Avery wasn't allowed to be there. And we played some games on our phones. Later, we went to the Fry Shack and got something to eat.
And what happened when you got to the Fry Shack?
Well, we saw most of the team there, including Alex Cifuentes. I think it was really hard for Avery to be with the team, and he got really visibly upset, so we had to leave.
Where did you go after you left?
We hung out at the mall, and then we just kind of went our separate ways for the night.
Ms. Perkins, I now want to talk about the next day, March 6th, the day that Mr. Brackman died. How did this day start for you?
It was like any other day. I woke up, I got ready for school. Avery picked me up and, we're about to listen to some music and we were like, oh my God, like Avery's phone was missing.
So what did you do about that?
Being the phone addicted screenagers that we are, admittedly, we decided to skip school and look for the phone. I mean, we looked all day and just never ended up making it back to school.
And what did you do specifically to try and find Avery's phone?
Well, I texted him and called him just to see if we could hear the phone or maybe someone else would pick up. But that didn't get us anywhere. So we decided to drive around and retrace our steps.
So where did you drive to first?
Well, first we went to the mall and we looked around in just so many stores. It was a huge hassle and nothing. We didn't find it.
So what was your next step after the mall?
Next, we drove to the Fry Shack. Yeah, I specifically remember that Avery had it when we were at the Fry Shack. So I figured, maybe he left it on the table or something before we left.
Do you remember what time it was when you got to the Fry Shack?
Actually, no. I don't know the actual time, but I know that it was sometime in the afternoon. We spent the whole day searching for the phone and we checked in with the afternoon shift staff at the shack.
So what else happened when you were at the Fry Shack?
Well, we never found Avery's phone, but we did see the rest of the team there, which was really weird because they were supposed to be at practice, but apparently Coach just never showed up. It's just so sad to think that he was, while we were there.
Ms. Perkins, I can see that this is a very emotional matter for you. I only have a few more questions. Now, you said that you had your phone with you on the day Mr. Brackman died while you were with Mr. Becker. Was your phone ever searched for evidence?
No, it wasn't. I was never asked to bring it in or to have it searched or anything like that.
Ms. Perkins, you've told us about your very close friendship with Mr. Becker, but would you ever consider lying for Mr. Becker's benefit?
Oh, of course not. Oh my God, especially not here under oath. I understand how high the stakes are today, and it means that testifying about the truth is so important.
Now, Ms. Perkins, was Mr. Becker at Mr. Brackman's house on March 6th?
No, I was with Avery all day on March 6th. That means there's no possible way that Avery could have committed this crime because Avery was not at Coach Brackman's house. Avery was with me.
Thank you, Ms. Perkins. Thank you, Your Honor. I have no further questions for this witness at this time.
Thank you. Cross-examination, Ms. Dino.
Yes, Your Honor. Ms. Perkins, you and the defendant were very close, correct?
Yes.
You were best friends, right?
That is true, yes.
And if he was in trouble, you would want to help him out, right?
I'm sorry, could you repeat that?
if he was in trouble, you would want to help him out, right?
In theory, friends do help each other out, I suppose, yes.
In fact, on multiple occasions, you made sacrifices for Mr. Becker.
Objection, Your Honor. This is improper character evidence.
Any response, Ms. Dino?
Yes, Your Honor, this testimony is not being used to prove any sort of character trait of Mr. Becker's or Ms. Perkins, and it's not being used to prove that either of them acted in conformity with that character trait. It is merely just going over the events that occurred between Ms. Perkins and Mr. Becker.
Ms. Shapiro?
Your Honor, this question was asking, the way that Ms. Dino phrased this question is that on multiple occasions, Ms. Perkins had tried to help Avery. This directly relates to propensity evidence and suggests that Taylor Perkins would then try and help Avery in the same way here in court today, which would dangerously mislead the jury.
All right, I'll note your objection. I am going to overrule it and allow the witness to testify. Go ahead, Ms. Dino.
Yes,
I'm going to repeat my questions, Ms. Perkins. On multiple occasions, you made sacrifices to help Mr. Becker.
Oh yeah, we've been best friends for a long time. So, as best friends do, we help each other out sometimes.
Right, so you gave up your spot on the mock trial team for him.
I did.
And you also gave up your entire day just to help him find his phone, correct?
You know what? I love spending time with Avery, so I don't even consider that a sacrifice. I mean, that was just fun.
And on Thursday, March 5th, you were with the defendant at the Fry Shack, correct?
Yes.
And Mr. Becker had his phone with him, right?
I do remember that. Yes, for sure.
He was very attached to that phone, wasn't he?
Yeah, we both really love our phones a lot. It's kind of bad, but phones.
So you really love your phones, but you testified that he forgot it once at the table going to cool off and again when leaving the Fry Shack?
Yeah.
After you left the Fry Shack, you guys went to the mall, right?
We did go to the mall.
You just hung out there.
Yep.
And the entire time you were at the mall, Mr. Becker never tried to check Snapchat, text his friends, or call his mom?
Objection, Your Honor, this is a compound question.
Any response, Ms. Dino?
I can rephrase my question, Your Honor.
All right, I'll sustain the objection. Go ahead and rephrase, Ms. Dino. Thank you.
Ms. Perkins, the entire time you and the defendant were at the mall, Mr. Becker never took out his phone for any reason.
I suppose not. I mean, we really value our time together and we just had quality time together.
Because if Mr. Becker had tried to check his phone for any reason, he would have noticed it was missing, correct?
Right, which means that he didn't check his phone at all.
In fact, the defendant didn't realize his phone was missing until you brought it up.
That is correct.
So Mr. Becker didn't use his phone at the mall. He didn't look for a text from you that morning.
Objection.
And only...
Your Honor, again, this is a compound question.
All right, well, let her finish and then we'll figure out. Go ahead and ask your question, Ms. Dino.
Ms. Perkins, Mr. Becker never look at his phone at the mall. He didn't try to look at it when he picked you up. And only then he realized that it was missing when you brought it up.
All right,
That's
I'll
cool.
allow the question. You can go ahead and answer it, Ms. Perkins. Go ahead. Thank you.
Well, yes, that is true. He didn't look at his phone until we were going to play music the next day and realized it's just not there.
However, in your own words, you and Mr. Becker were phone-addicted screenagers, correct?
That is true.
The next day on March 6th, you say you spent hours driving around looking for his phone, correct?
Yes,
You went to the mall.
we did.
You went to the Fry Shack.
Yes.
But the iCloud website could have easily tracked it.
Well, I have an Android, so I just totally forgot that that feature is even possible.
And Mr. Becker just forgot?
Yes.
Now, Isn't it true that you actually have no personal knowledge about whether Mr. Becker actually lost his phone or not?
That is incorrect. Avery did lose his phone, and I know this because I called and texted Avery repeatedly, us not hearing anything from the phone. I mean, that's the whole reason we skipped school, right? It was to look for the phone.
I will rephrase my question. The only personal knowledge you have about Mr. Becker losing his phone is what he told you after you brought up the idea, correct?
No, that's false because I was also with Avery, and so I was able to know that Avery didn't have his phone.
On direct, you testified about a mock trial practice where everything blew up.
Oh, yes.
You weren't there that day, were you?
No, I was not.
In fact, you don't have any personal knowledge besides what the defendant told you about what happened. Isn't that correct?
Well, not just the defendant, it's the whole team, right? The whole team talked about it. And given that it got Avery kicked off the team, I think it's fair to assume that the event did occur.
You testified that you think Blair Rowlands could have been involved in Coach Brackman's death.
Blair is whack. Yeah.
It was the defendant that came up with this theory, wasn't it?
I mean, Avery and I both think Blair is kind of weird, so it's kind of both of our ideas, I guess. I don't know.
Ms. Perkins, do you recall giving a witness statement in this case?
I do.
And do you recall saying that after it was Mr. Becker that brought it up, that's when you thought of Blair Rowlands as a suspect?
Yes.
In fact, it would surprise you if he was involved, wouldn't it?
If who was involved?
Blair Rowlands was involved in Coach Brackman's death?
Yes.
In your own words, you thought that never in a million years you would have guessed Blair Rowlands did it.
Yes.
You testified that while you and Mr. Becker were driving around, you were nowhere near Coach Brackman's house.
That is correct.
So you know where his house is?
Yes, he's been my mock trial coach for 4 years.
Ms. Perkins, you do know where Coach Brackman's house is?
Well, I suppose that I do know where it is because I know we were nowhere near it.
Thank you, Ms. Perkins. And it's logical to assume if you know where Mr. Brackman's house is, you do know that Mr. Becker would also know where his house is.
Objection. This question calls for speculation.
Ms. Dino, any response?
Your Honor, this witness has consistently testified that she and Mr. Becker are best friends. They also spent all day driving around near the neighborhood, so it's logical to assume that this witness would know if Mr. Becker knew where Coach Brackman's house was.
Ms. Shapiro?
Your Honor, Ms. Perkins would have no idea about Avery's inner thoughts, and any question that asks Ms. Perkins to speculate to that is inadmissible and cannot be heard by the jury.
All right. I think it's an appropriate question. I'm going to overrule the objection. You can answer it if you know, Ms. Perkins.
Would you like me to re-ask the questions, Ms. Perkins?
I don't think that'll be necessary. Just because Avery and I are best friends doesn't mean that I know everything that Avery knows. So therefore, no, I have no clue if Avery knew where Coach's house is.
Ms. Perkins, were you at Coach Brackman's house on March 6th?
No.
Are you sure?
Yes.
And do you recall giving a witness statement in this case?
Yes, I do.
And do you remember saying, it was creepy to think about Brackman bleeding on his porch?
Yes, yes.
Whoever it was that first called 911 also said that Coach Brackman was on his porch. Correct?
That is correct.
The two of you have identical, incorrect accounts of where Coach Brackman's body was found. Correct.
That's correct. Look, we're best friends. We talk a lot. And so we both obviously had the same misconception.
So my question was about the unknown 911 caller. Are you now testifying that that unknown 911 caller was your best friend?
No, I'm not.
So you just stating that you two sometimes have the same misconceptions, referring to Mr. Becker, did you get them confused?
No, actually, I'm apologizing. I misheard your question. I thought you said Miss Becker testified that.
No further questions, Your Honor.
Thank you. Any redirect?
Briefly, Your Honor. Ms. Perkins, what does it mean to be someone's best friend?
Well,
Objection. Relevance?
Ms. Shapiro?
Your Honor, a redirect examination may respond to anything that was brought up on cross-examination. What was brought up on cross-examination is Mr. Becker's and Ms. Perkins' very close relationship, and I believe that Ms. Perkins deserves the opportunity to testify about that relationship once more.
If I may, Your Honor?
Dino?
Yes. My objection was not to scope. It was in fact to relevance. And under Rule 401A, the fact of what Ms. Perkins believed best friendship is does not make the fact more probable. Therefore, it is not relevant to this case.
All right, I'll note your objection. There was quite a bit of testimony about the friendship between these two, so I'll allow it. Overruled. Go ahead.
Ms. Perkins, would you like me to re-ask the question?
yes, please.
What does it mean to be someone's best friend?
Well, when you're someone's best friend, you need to be supportive and you need to be honest. And as Avery's best friend, I can recognize his mistakes, like the car incident, but I'm here today to do the right thing by being supportive and showing everyone the truth about where Avery was on that day.
And just to clarify, is it your testimony in court today that Avery Becker was the person who made the 911 call?
No, that is not my testimony.
Thank you, Ms. Perkins. Thank you, Your Honor. I have no further questions for this witness.
Thank you. Any recross, Ms. Dino?
Briefly, Your Honor. Ms. Perkins, when I asked a question concerning the close relationship or the close accounts that you had with the unknown 911 caller, you responded saying that sometimes best friends can have the same idea. Isn't that correct?
That is correct, but my response was actually not accurate because I misheard your question.
No further questions, Your Honor.
All right, thank you, Ms. Perkins. You may step down. Defense, you can call your next witness.
All right, the defense calls Professor Blake Van Owen to the stand.
All right, thank you. Mr. Van Owen, go ahead and raise your right hand for me. Please, do you swear or affirm under penalty of perjury the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
Oh, absolutely, Your Honor.
All right, your witness, counsel.
Thank you. Now, Mr. Van Owens, I'm going to ask you a few questions, if that's okay with you.
Professor Van Owens, you know, I've graduated with a master's degree in criminal justice, and I also currently teach classes on social justice and police procedures. So, Professor, please.
I'm sorry. Professor, what is your current occupation?
Well, besides the teaching, I am a private investigator, and I was hired by Avery Becker to investigate the police's work.
Now, what exactly does a private investigator do?
Well, there's a quote my old buddy used to say, "What do we private investigators do? Privately investigate." That's what I do.
More specifically, what do you do?
Oh, well, jokes aside, we do a whole smorgasbord of things. We look into crime scene data, police reports, witness reports, cell tower data, and I testify as an expert witness in court. Emphasis on the expert.
So what is your experience with police procedures?
Well, I was actually a member of the Boys in Blue for 9 months. 9 months.
And you mentioned that you've testified in court as an expert before. What
Yes.
specifically are you an expert in?
Well, now you're going to make me crunch the numbers. So I have testified as an expert in police investigation 12 times, as an expert in crime scene reconstruction 8 times, and an expert in cell tower analysis 5 times. And overall, I have testified in well over 100 cases.
Thank you. Your Honor, we move to qualify Professor Van Owens as an expert in the field of police investigation tactics, crime scene reconstruction, and cell tower analysis.
Any objection, Mr. Dineza?
Yes, Your Honor. May I request a brief voir dire?
Briefly.
Thank you, Your Honor. Professor Van Owen, you claim to be an expert in police practices, correct?
Oh, not just any expert, the best expert, perhaps in the whole country.
But you were part of the police force for only 9 months, correct?
Right before I learned that the police are not the good boys that everyone says they are.
And that was back in 2005, correct?
Right, it's, oh my goodness, I guess it has. Yes, oh man, it's been an age.
So your purported expertise is based on a 9-month experience from...
No, actually, no, it's actually also based on my years of experience teaching it to the young folk who are hopefully going to go out and do greatness in the world.
Here's my question. Your direct experience in police work was from a 9-month experience over 15 years ago.
I'm afraid I'm not entirely sure what you mean by direct. In terms of actively involved with the police, yes, but I've done far extensive more than just those 9 months.
And you haven't had any recent training or certifications, correct?
Oh, no need to when you're already the best at it.
Your Honor, I have no objection to this witness being entered into the fields otherwise noted. However, as the only experience in regards to police practices was 9 months, was a 9-month-long tenure with the Aurora Police Department from over 15 years ago, I do object to expertise in regards to police practices directly.
All right, I'll note your objection, counsel, but I am going to let him be qualified as the expert in the areas that Mr. Trembath is asking him to be qualified in. So your objection's overruled. You may continue, Mr. Trembath.
Yes.
Thank you, Your Honor. Now, Professor Van Owens, what is your biggest pet peeve?
Assumptions. You know, picking evidence and trying to blow it out of proportion, even when there isn't any evidence. Conspiracy theories, just hate it. I hate assumptions. And I hate them even more when they're in a professional setting where someone's life is at stake.
Well, how did this pet peeve play into your work as it relates to the murder of Mr. Brackman?
Well, in my line of work, I like to consider myself an agent of chaos. I like to take these rock hard evidence that the police finds and throw it around. And I like to point out doubt. And in this case, in particular, counsel, I found a buttload of mistakes and assumptions the police made.
Now, let's dig into these mistakes and assumptions. What did you find about their usage of cell tower data?
Oh, starting out strong. Well, I found it to be wildly reckless, wildly clueless, and destructive. In fact, I found it so destructive that they are presuming so much off of some evidence that does not clearly define anything.
So why was their usage so destructive?
Well, because cell tower data is not as conclusive as prosecution may have tried to make it. Here, let me give you an example. If I were to have my phone and I were to try to turn it on and connect it, however, the nearest tower was busy, maybe with Christmas calls to grandma, maybe with family calls, whatever. My phone would then connect to another tower, which may be farther away, but it prioritizes which tower is less busy. Meaning that in this case, there is no guarantee that this didn't happen because this is quite, frankly, common. So we have no idea.
So if that's the case, how in any way is this data helpful?
Well, it certainly does one thing. It clarifies Taylor's alibi that he had tried to call phone, excuse me, it's getting a little late now. He tried to call Avery's phone to locate it.
Now, did the police properly collect anyone else's phone records?
No. No, in fact, they chose not to. They didn't gather Blair Rowland's phone data. They didn't gather Taylor Perkins' phone data. Heck, they didn't even gather Alex Cifuentes' phone data, who sent them screenshots that were supposedly real, but there is zero evidence, zero, to clarify that.
So how exactly did they fail to gather Alex's text messages?
Well, I want you to imagine you are an investigator, and I want you to imagine that you have to consider everyone. That's not what happened. In fact, that is far from what happened. They chose to follow their intuit that Alex was true on Avery's presumptions because they already thought that Avery was the main suspect. And so they didn't even bother to look into Avery's text messages. Heck, they didn't even secure his phone. We don't know who these were sent from. They could have been from grandma. We don't know.
Thank you. Now let's move on. How did your investigation of Avery differ from that of the police's?
Well, I certainly didn't use maybes and probablys. In fact, Cusack, I would like to clarify something that you said on your stand today. You used the word probably when addressing to certain evidence, and I would like to address that directly. And in fact, I would like to address the scuff marks made near the back door, the ones that you said were maybe probably caused by Brackman's shoes. In fact, the reason it's probably is because you didn't test them. You didn't look at the dating of them. You didn't test whose shoes caused them. Heck, you even said you didn't even know where the scuffle occurred. So what can we believe about it? Nothing. There is no forensic evidence. Nada, zero, N-O-T-H-I-N-G, nothing that points to it being related to this.
Wow. So what else did the prosecution's investigation assume about the scene of the crime?
Well, they certainly assumed a heck of a lot about the Ring video, the little doorbell doohickey you'll usually see out of a lot of rich folks' homes. They assumed a lot with that. In fact, they assumed four things. They assumed A, that Brackman's phone got a notification. B, that Brackman saw this notification on his phone. C, that Brackman immediately perceived it as a threat. And 4, that Brackman then headed over to his kitchen and grabbed a knife in self-defense. Now, I want you to ask yourself, where is any of the evidence to back this up? Ding, 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 that's right. Nowhere. There is no evidence to back this up other than their own assumptions and probablys.
Wow. All right, well, it sounds like they made a few assumptions, but at least the prosecution didn't lose any critical evidence, right?
Oh, my friend, if only you were right. No, in fact, they only lost the most critical part of evidence, the forensic type. They lost all of the blood spatter evidence. I didn't even get a chance to look at it because by the time I asked for it, I learned that it was corrupted, all of it. Now, I know they didn't intentionally corrupt it. I just assumed that they bumbled it like a bunch of other evidence. However, this could have even supported their own theory of the case, but we don't have it anymore because they lost it in their oh so diligent investigation. We don't have it.
Wow. Now, moving on, you mentioned alternate suspects earlier. Who were you referring to?
Well, in all frankness, counsel, I can't say for sure. I mean, Brackman had a lot of clients. Brackman had a lot of students, which of course the police didn't investigate because why would they? But I did find evidence pointing to a potential alternate suspect, Blair Rowlands.
Who is this Blair Rowlands?
Right, so Blair Rowlands is the son of an ex-client of Brackman who was sent to jail for life during a very vocal trial.
What did you find about this Blair?
Well, I found a lot of facts, actually. I found that Blair was not at school the day of the murder. I found that Blair had a very similar build to the person in the Ring video. And I also found that Blair was with Alex Cifuentes, who was the last person seen with Avery's phone.
So what did the police report say about Blair Rowlands?
That's a great question. What did the police report say about Blair Rowlands? A whole heaping big Mount Everest of nothing. Of nothing. They did not even bother to look into it.
So what is your final conclusion on the police's work?
Well, thankfully, the police made my conclusion quite easy. They messed up. A lot. You see, evidence is key to a case. And without that key, you can't then expect to unlock the case. And ladies and gentlemen, there is no evidentiary key to convict Avery of this murder.
Thank you, Your Honor. No further questions.
Thank you, counsel. Any cross-examination?
Yes, Your Honor.
Go ahead.
Professor Blake Van Owen, one of the reasons you quit police work is because you became disillusioned with it.
Yes, frankly, I did.
And this is because of an incident in which you were sued, correct?
No, it was due to an incident in which the police approved of tactics I deplore.
However, this incident ultimately resolved with a civil suit, correct?
Right, yes.
Objection, Your Honor. Relevance and this line of questioning is far more prejudicial than it is probative.
Mr. Dineza, any response?
Yes, Your Honor. In response to the relevance, this line of questioning is being used to establish bias. Professor Blake Van Owen became disillusioned with the police force and thus has an inherent bias against them. In response to the more prejudicial and probative, for that to apply, the prejudicial value would have to substantially outweigh the probative value. In this circumstance, the probative value of bias substantially outweighs the prejudicial value.
Thank you. Mr. Trembath, any reply?
Yes. This line of questioning is referring to an event that Professor Blake Van Owen was a part of, and this event is what is far more prejudicial than probative. And the relevance of any bias that he would have against the police has no impact on his investigations of the murder of Coach Brackman.
All right, thank you. I'm going to go ahead and allow the evidence to demonstrate bias, so I'll overrule the objection. You may continue, Mr. Dineza.
Yes, Your Honor. And since that time, you've considered yourself a bit of a crusader for social justice, correct?
Oh, a little bit, yes.
And that's what you teach, social justice, correct?
Yes, at CU Boulder.
And I'd like to clarify a statement you made during your tendering. You stated that you were entered as an expert 100 different times, correct?
A little more than 100, yes, over 100 times.
However, in your witness statement, you specifically wrote you consulted in 100 cases, correct?
Right, but that also includes testifying, yes.
Now, and all of these times you've consulted or testified, they've been for the defense, correct?
Right, I have no need to go for the prosecution. I mean, you already see the boys in blue doing that for me.
And in each of these 100 or so cases in which you've consulted for the defense, you are paid for your opinions.
Yes, of course. I mean, I need some way to feed my husband, Charlie.
And this is between $6,000 and $10,000 per case.
Right, yes.
Now, let's move on to your evidence. You were retained to review the investigation the police conducted, correct?
Right, yes.
And your job was to find something wrong.
Absolutely.
But you didn't do your own investigation of the crime itself, did you?
No, it was long since cleaned up by the time I got the case.
You were unable to visit the scene of the crime?
Again, yeah, I could only base my opinion on the police's work, which was shoddy.
Unable to take any pictures on the scene?
No, and I would have had my I would have had my own pictures had the police not lost them. Yes, I would have had my own pictures had the police not lost them.
And in addition, you were unable to view Mackenzie Brackman's body?
Right. Well, besides the pictures, yes.
But Detective Markowitz did, didn't he?
I wouldn't say he viewed it very well, but I would say he looked at it, yes.
And so did Kyle Cusack, didn't he?
Same thing. I would say that they gave it a look over, but that's about as clear as the Hudson Bay in New York.
Thank you. Now let's move on to your the investigation itself. You testified that, in your opinion, Detective Markowitz neglected potential evidence, correct?
Oh, absolutely, yes.
And you think he should have obtained Taylor Perkins' cell phone records, correct?
Oh, yes, absolutely, he should have.
And the complete Ring doorbell records as well?
Yes.
But you never obtained this information, did you?
Well, by the time I couldn't, there was a very brief window when Taylor could have, there's a very brief window when this evidence existed, and then afterwards it gets terminated, so I could not.
In which you could obtain the evidence? My question was if you obtain this evidence, yes?
No, well, I'm saying I could not. It was physically impossible for me to.
And it's your theory that Brackman was surprised in his house and stabbed in the back, correct?
Yes,
And you believe the intruder brought their own knife as well.
absolutely. Yes, I believe that.
You reviewed all of the images the prosecution provided.
Oh, 100%.
You also reviewed the coroner's report, correct?
Yes, every little word.
As an expert, you relied on both of these things to make your.
As any good expert would, yes.
In this autopsy report, the incision was said to be approximately 7 inches deep, correct?
Approximately, yes, I believe that's what the coroner said.
So would it be fair to assume the blade is approximately 7 inches?
Yes, I would absolutely say so.
So this would mean the knife itself would be give or take 11 inches, including the handle.
Well, I can't do that because that would be presumptive, so I cannot say. But I do say that the blade has to at least be 7 inches.
Now, would it be fair to assume? Okay, we'll go with that. And after reviewing the photos and videos of the intruder's not holding a knife, correct?
No, they were hiding it under their clothes.
However, this would just be an assumption, correct?
No, it's based off of the facts that I saw within the house.
You have any evidence telling you that the intruder has a knife concealed in their clothing?
I have every piece of evidence to point to the fact that the blade did not come from inside the house. So there is only one logical place it could have come from,
Professor
other
Van,
than aliens.
My question was, do you have any concrete evidence saying that the knife was concealed within the clothing itself?
Yes, the absence of evidence is as strong as evidence itself.
Time, Your Honor.
You're out of time, Mr. Geneza. Thank you. Any redirect, Mr. Trembath? I think you've got about 30 seconds.
No redirect, Your Honor.
All right, thank you, Mr. Van Owen. You may step down.
Thank you, Your Honor.
All right, it's time for closing arguments. Any closing argument from the prosecution?
Yes, Your Honor, and I just want to confirm that any remaining time be reserved for rebuttal.
Yes.
May I proceed?
You may, thank you.
Thank you for your time and attention. Everyone has a breaking point, and Avery Becker is no exception. After an endless barrage of criticism, insults, demotion, and hatred from his mock trial coach, Mackenzie Brackman, Avery Becker hit his breaking point. And in his own words, he would get back at Mr. Brackman if it was the last thing he did. And that is why we are here. The evidence and testimony has shown that Mr. Becker, while attempting to vandalize Mr. Brackman's home, was surprised by his presence, and in a fit of rage and fury, fought him for control of his knife, consequently stabbing him in the back. Now, the defendant has been charged with 2 crimes: first-degree murder and second-degree burglary. To be guilty of first-degree murder, the defendant must have knowingly and unlawfully broken into the home of Mackenzie Brackman and during that invasion killed him. To be guilty of second-degree burglary, the defendant must have knowingly broken into the residence of Mackenzie Brackman with the attempt to vandalize. Now, the evidence has shown the critical elements of these crimes beyond a reasonable doubt. Let's walk through them. First, motive. Mr. Becker had clear motive to break into Mr. Brackman's home. You heard about how mock trial was his life, how he hoped to win awards at state, and how Mr. Brackman stood in his way. You heard about their tumultuous relationship, the arguments that led up to his demotion to the B team, and finally, when he got so angry that he took a Sharpie and wrote on Mr. Brackman's car. He snapped. And when he was finally kicked off the team for good, he decided to get revenge. He hit his breaking point. Now, with that motive in mind, let's look at intent. Mr. Becker clearly intended to break into and vandalize Mr. Brackman's home. First, he talked to his mother, where he stated that he would get back at Mr. Brackman if it was the last thing he did. Then, he texted Mr. Cifuentes in a final effort to get back on the team. But when he realized there was no hope, he again stated that he would wait until Mr. Brackman was at work, then break into his home and trash it. And so, he established a false alibi with his loyal best friend, Taylor Perkins, skipped school, and killed Mr. Brackman. Now let's talk about this alibi. You heard about the unwavering friendship between Mr. Mr. Becker and Miss Perkins, how they were best friends, and Miss Perkins joined mock trial, quit mock trial, and would have done anything for the defendant. That alibi is biased and not credible. And Mr. Becker's story about losing his phone, a boy who joined mock trial to be on his phone, a boy who was on his phone at all times, a boy who didn't notice his phone was missing when he was supposed to turn it into his mom at night, well, that story is not credible either. So with those in mind, let's look at means. Mr. Becker clearly had the means to break into Mr. Brackman's home. Mr. Kuzak and Detective Markowitz explained how all of the evidence pointed to Mr. Becker. Detective Markowitz explained the call detail records that put Mr. Becker at the crime scene at the time of the murder. Now, the defense wants you to believe that Mr. Becker is a good student with good intentions, but they fail to acknowledge the anger that lies dormant below the surface. Mr. Van Owens wants you to believe that this is a flawed investigation, but not one of his conclusions are based on his own observations. And he hates the police force. He's being paid today. His testimony is inherently biased. Now, as you deliberate today, I want you to think of Mr. Brackman, a man who fought for justice every day, a man who taught others to fight for justice. Do not let justice fail him. Do not let Mr. Becker get away with his quick breaking point. At the end of the trial, we ask that you reach the final verdict of guilty on all counts of murder. Thank you.
Thank you, counsel. Closing argument for the defense, please.
Yes, Your Honor. What happened to Mackenzie Brockman on March 6th of 2020? It seems that every witness in the courtroom has a different answer. The truth is, we don't know, and that's because the police investigation was fatally flawed. Asking you to rule in this case is like asking someone to complete a puzzle when they've only been given half the pieces. Because this puzzle has hundreds of pieces, and the prosecution used less than half. The prosecution was hyper-focused on Avery from the very beginning. The police zoomed in on this puzzle and tried to make you see only one section. We're asking you to look at the whole puzzle. Because when you do, you will see this isn't a picture of guilt. The police misread this puzzle. In reality, the full puzzle would show Avery Becker's innocence. Detective Markowitz called one person on the mock trial team. He told him it could be Avery, and he never looked anywhere else. Never looked into other suspects, a possible vengeful client, or a past enemy. He assumed the text messages were real, and he chose not to download anyone's phone data. How are we supposed to believe his conclusions when we can't even see the real evidence? The photos of the blood spatter were destroyed. It's like throwing puzzle pieces out the window. The prosecution also brought Kyle Kuzak to the stand. Something Kuzak and Markowitz have in common: they make conclusions based on assumptions. Kyle Kuzak came up here and told you that Blake Van Owen makes conclusions before looking at the evidence. Well, that is exactly what he did. He said he was presented with the pieces and he just put them together. Well, he put together an incomplete puzzle and he never looked for any more pieces. He assumed the knife was from the home. He assumed there was a struggle when there were no other injuries. And he assumed it was Avery Becker when there was no DNA and no physical evidence. They also brought Alex Cifuentes to the stand. We showed you that you can't trust Alex. He told you that he had Avery's phone the very night the text messages were sent. And now he's gotten a new phone and is unable to show you anything other than a photo. There are serious questions of authenticity of these texts, and we'll never know the truth because the data wasn't downloaded. Then you heard from Avery Becker. Avery told you how much he loved mock trial, and he would never want to hurt Brockman. They said that Avery hit his breaking point, but he came up here and told you that he didn't. He told you that he doesn't even know where Brockman lived. And Avery told you where he was that day. He was with Taylor Perkins all day long. They went to the mall, then the fry shack, and then they went home. Where was Blair Rollins that day? We don't know, because no one ever asked. We do know that Avery and Blair were friends, and that Blair had a grudge against Brockman. You also heard from Taylor, who confirmed the truth about her and Avery. And she told you that there is no way she would ever lie for Avery. She's only here to tell the truth, that they spent the day together. She also told you that the police never contacted her, never downloaded her data, and if they had checked her phone, they could have seen where they were. Finally, you heard from Professor Blake Van Owen. He told you just how fatally flawed the whole investigation was. He told you that he tried to reach out to Avery and Blair, and they refused. He told you there was no way of knowing where Avery or even Avery's phone was that night. And he told you that this case was strung together by maybes and probablys. But that's not good enough. Maybes and probablys are reasonable doubt. We would like to remind you the prosecution had the burden of proof. They had to prove Avery Becker broke into the house and Mr. Brockman was killed. Now, we don't dispute those events, but we dispute the suspect. They brought you no DNA, no fingerprints, and no photos to prove Avery was ever at the residence. They failed to fulfill their burden of proof. There are too many pieces taken from this puzzle, and if you look at the full picture, you will see that this is a puzzle of innocence. Thank you.
Thank you, counsel. Any rebuttal from the prosecution?
Yes, Your Honor. May I proceed?
You may. Thank you.
The defense is trying to add pieces from a completely different puzzle to this investigation. There is no factual evidence that Blair Rollins was involved. A different puzzle. Mr. Van Owen's baseless and biased conclusions, a different puzzle. The only correct puzzle piece that they have presented to you is Taylor Perkins telling you that Avery Becker was the 911 caller who reported Mr. Becker's death. The true and factual puzzle has all of the pieces and shows a clear picture of guilt. Guilt and Mr. Becker's breaking point. Please find him guilty. Thank you.
All right, thank you, folks. We're going to take a few minutes. The scoring panelists need to submit their scoring sheets, and once that's completed, they will pop up on the screen, and then we will give you our closing comments. Thank you. All right, it looks like all of our scoring panelists have joined us, which means that we can offer our final comments. I don't know if the attorneys or the witnesses want to turn on their cameras. It's always nicer to see everyone rather than talking to an abyss. I just want to say thank you all for all of your obvious hard work. All of you did an amazing job, and every time I volunteer to help out with mock trial, I'm always blown away by how amazing you all are, and how I think any number of you could come into a courtroom and try a case as it stands right now. I sit on this bench day in and day out and see definitely some lawyering that pales in comparison to what I saw today. So thank you for that. Just a couple of things that I noticed, and then I'll hand it off to the scoring panelists for more in-depth comments. Things I liked, each side had a pretty consistent theme, and I thought that was well done. The prosecution with their breaking point, the defense with the flawed investigation, and really kind of carried that through all the way to the end. And then with Ms. Seaman, with her rebuttal close, kind of took the defense's theme about the puzzle and attempted to use it against them. So I thought that was a good example of thinking on your feet, and a good example of all of you carrying that theme entirely through your cases. On cross-examination, I'm a big fan of making a statement and asking it as a question, but not really asking a question. And a lot of you did that, and that's probably due to your coaches. You know, things like photos are important, and then you just leave it hanging out there and wait for the witness to answer that question. I think that's a brilliant way to cross-examine, and that's how I learned how to cross-examine as a young prosecutor from some of the best people in the business. So, but I have to say some of my favorite parts of this trial were from the witnesses. I thought the witnesses were fantastic. The way you presented your case, the way you pushed back, the way you answered questions on cross-examination, giving way more than what was asked for, and forcing the attorneys to say, I just need a simple yes or no. That's real life stuff, and so I really appreciate that. I thought the witnesses for both sides really, really hit it out of the park. I have to commend Mr. Guevara, though, for his incredible use of the Zoom camera and, going like this and really taking up that space and looking and really taking a witness that I think everybody can agree has some credibility issues, and at least making him entertaining for the jury, fiddling around with things, taking off the glasses, all of that, very, very deliberate actions. I enjoyed. I'm supposed to have a poker face up here. I couldn't do it when Mr. Guevara was testifying both on direct and cross, so kudos to you, sir. But that's not to outshine the hard work and the great case that all of you put on. All of you really do deserve to be commended for all of your efforts here. So congratulations to all of you. I'll hand it off. And I know I do Zoom, I do WebEx every day. I know how difficult this must be, not coming into a courtroom, not having that personal interaction. And you guys just took the WebEx or the Zoom and just ran with it, and thoroughly impressed. It's like you've been doing it for years. It didn't seem to trip anybody up, and so I have to commend you for that, for being able to handle this virtually in such a smooth manner. It really speaks volumes to the hard work you've put in. So in that vein, I'll call on our panelists so they don't talk over each other. I'll just go in alphabetical order. Ms. Henson, I'll start with you. Go ahead.
Yeah, so I agree with you. Andres really stood out to me. His performance as a witness, I was kind of just sitting here laughing at him. At first I was like, oh, this is a little bit over the top, and within like 1 minute I was totally sold on the character. And I thought that Henry did a really nice job. The interaction between the two, they worked together really well, and the questions that he asked really allowed him to kind of push that character the best he could. I think everyone had a great grasp on the case, was obviously super prepared. very obvious that you guys spent a ton of time preparing and practicing, not looking at notes at all. It was very, very impressive. Great job, you guys.
Thank you. Ms. Johnson-Stern.
So I have a bit of a cold, so excuse me, but I agree with everything that's been said already. You guys are all so really good at this. Excuse me. I thought the witnesses as a whole were all very convincing and very credible. You guys all really knew the material, and I found every single one of you did very well on cross and really dealt with everything beautifully, I think. You weren't argumentative. Nobody got defensive, which is not easy to do. And I just commend you all. You guys, all of you witnesses were really, really good and really lovely to watch. The attorneys, you guys are so skilled. What I really appreciated in all of those directs is there wasn't a lot of ums or ands or then. Your questions flowed very well. You avoided that tendency once an answer is given to sort of confirm it or say, okay. You guys really did well. Your questions flowed beautifully. I thought they all made sense. They were very easy to follow. And you told your stories very well through that direct. And that's not the most fun part of a trial, but it is absolutely the most essential, in my opinion. That is how you make your case first and foremost through your direct examinations, and you guys all did very well. Cross-examinations, I thought you guys all really maintained a very professional demeanor, and that's also not easy on cross. On cross, sometimes it's a natural tendency to feel that you're in conflict with that person, but you guys all really did a great job of getting to your point, which also is not easy to do. Your cross questions were all very relevant. They flowed very well. And you guys really handled your objections well, both in launching your objections and defending or responding to those objections. You guys really are very strong teams. In terms of, so the single thing that if I had to find anything to kind of help some of you get a little bit better, what I might say to Ms. Seaman, Mr. Dineza, sorry, I'm just, Mr. Trembath, and Miss Angevine, you all had really strong times when you were very conversational, your questions were flowing well, your points were well made. I did see just a little bit of inconsistency. So what I might do is sort of take those pieces. So for example, Miss Seaman, your closing was perfection. And so the only thing I might say to you, if you can, is that energy and that detail and that passion you brought to your closing, if you could sort of try to be more consistent in terms of that across the board. Again, and I'm hard pressed to find any kind of difficulty with that, but you certainly, as it went on, you seemed to become more comfortable and more confident in your role. And that I noticed a difference. And I would say that about all of you that I just mentioned. In terms of Miss Dino and Miss Shapiro, you guys were very consistent. I thought from the moment you stood up to the last words out of your mouth, you guys maintained perfect, credible demeanors. Your crosses were good. Your everything you did was very good and concise and passionate and engaging. And I would really like to compliment you two on that piece. That said, everybody was exceptional, and you were all a pleasure to watch. I really am pleased to get to be a help to you, or not a help, but an audience. Thank you.
Thank you. Jacqueline LaFerriere.
Yes, thank you, Your Honor. I agree with everything people have said so far. I think you guys did an excellent job. Like Barbara said, direct is such an important thing, but it's super boring if all you do is say, and then what happened, and then what happened, and then what happened. And I feel like you guys avoided that a lot. Ms. Seaman, especially, you gave some really good guideposts and repeated what you needed the witness, or what you needed the jury to remember about the last sentence, because sometimes the jury will be completely checked out. But I feel like you did a really good job of clarifying that. Mr. Dineza, you did a great job of handling a very difficult witness. And unfortunately, some expert witnesses really are. So you have to be good. I thought you challenged ability really well and just handled him very well. Mr. Trembath, you did a great job. I appreciate that you tried to impeach on a prior statement. That's really difficult to do. Your direct was really interesting. Ms. Shapiro, you did a great job getting the witnesses to commit, which is hard. Ms. Angevine, you did a great job with your objections. And Ms. Dino, I listened to your questions only. I didn't care what the witness said. And that's exactly what you want to happen on cross-examination. That was very solid. So well done. And yeah, I mean, I think you guys did a great job. I think, you know, a little bit more of, I guess, changing up the cadence keeps things interesting, kind of what Barbara said, and the energy and everything like that. But yeah, excellent job.
Thank you. And Alan Pogue.
Thank you, Your Honor. I'll echo what the others have said. I thought you were all fantastic. Real quick, I've been a mock trial coach and judge and presiding judge for a while. This is as good or as well prepared a trial as I've seen in my time. And the fact that you did it all on Zoom is even more impressive, because there's a few old people, I'll age myself, not anyone else, that have had to get used to this. And you guys are probably better at it than we are, but you did very well with it. So well done. I think just in terms of some quick comments, what I liked about this, and every lawyer has his or her own preference and style. I don't care for dramatics and theatrics and yelling, and I didn't see any of that today. I saw professionalism and people that understood the rules and made great arguments without pretending like they were on TV. So fantastic job from my perspective on that. Mr. Sharp, I thought you did a fantastic job as the defendant. You had the right amount of, I'm really sad about this, but you weren't over the top. So I thought that was really good. Miss Angevine, Miss Shapiro, you guys are fantastic. Your cross-examinations were good. Your directs were good. Somebody already said this, Miss Dino, your cross-examination was off the charts. Direct is more important to me than cross in a trial, but you can get a few on cross, and you've got a few. My last thing, Miss Seaman, when you graduate, if you go to law school and you want a job, give me a call, because what you did today was off the chain, if that's a term that you guys still use. Really good. Absolutely fantastic. Great job, all of you. It was fun to watch, every single one of you.
Thank you.
Well, thank you folks so much for a fantastic trial. It was a pleasure to preside over, and obviously everyone enjoyed scoring it as well. So best of luck moving forward, and give yourselves a big round of applause. Thank you all.
Thank you so much.
All right, I think that's it.